No,
one কেন লিখতে যেটা চলছিল last? What was being argued lastly by Mr. Banerjee? Which was the item number?
Item 4.
Which item was going on?
item 5.
Item 5.
Item 4.
6 and 5.
1, 2, 3, and 4, the state has concluded.
My lord,
1 to 4, state has concluded.
my lord, last occasion, my lord, yesterday, my lord, your lordship, certain my lord is falling from your lordship, my lord, they, my lord, about to take instruction and come back to your lordship.
Nobody is here.
Now, my lord,
Mr. Singh, you appeared in which matter? Where is Mr. Banerjee?
These on legs just coming here, Lordship. We're praying just a short pass over.
pass over করলে তো মুশকিল হবে সারাদিন ধরে কন্টিনিউ ম্যাটার
Ask Mr. Banerjee to come.
our submission your lordship may recapitulate my lord this my lord 4 my lord last Mr. Mojumdar also submitted and my lord after Mr. Sannal my lord 3 4 my lord they have not yet answered my lord that the teacher people ratio as per the schedule my lord of RT my lord, whether it is my lord student ratio my lord in respect of the school or the class and my lord the contrary to the rule and my lord anything my lord these my lord not yet my lord they have answered possible এগুলো অন্য মামলা ধরে নিয়ে এইটা ওরা কালকে রিলাই করেছিল
করুক না the difficulty is that we are hardly pressing for interim order. Of course, subject to
I
your
have
loss.
placed it today to complete the hearing.
That's your loss. In this sort of matter, they should be present at least.
Need to pass over up. Inform him. The other matters have been argued by the state.
Yes,
What else?
We have to
Only
give
item number 5 he was arguing, he places.
just we have to give simple reply to some points. If loss requires at all. The teachers are gossiping alleged. I don't know, my lord. What's
Yes?
No, because they allege that teachers are gossiping. Not what we are doing, my lord.
Anyway, so next document. We mentioned the document.
না না 500 বাদ দিছে
Yes. Now, this matter, my lord, I do not know, my lord, why, my lord, it was mentioned. We have not received any notice. Now, my lord, in order to release this matter, I do not know. This is, my lord, with deepest of respect, my lord, your lordship has the determination. These petitions were taken up by your lordship on number of occasions. Now, today, my lord, this prayer is not maintainable, my lord. I have brought judgments, my lord, on this Supreme Court, my lord, deprecated this practice. A judge has every right to, my lord, release a matter. It is the prerogative of the judge. A counsel, my lord, cannot make such prayer. The Supreme Court says this should be nipped in the bud. This is a forum shopping or bench hunting. Now, my lord, this is a prayer. If it comes, my lord, from a learned counsel, my lord, this is very unfortunate, my lord. And, my lord, your lordship, kindly recollect this. This matter was taken up by your lordship. A bunch of matters was taken up by your lordship. Then, my lord, your lordship was pleased to pass a direction to file affidavit in opposition. We filed our affidavit in opposition. Then, my lord, the hearing matters were taken up. The Mr. Vikas Ranjan Bhattacharya, learned senior counsel, he concluded his submission. Then I started my argument, and my lord, it was taken up at least on 2 occasions. And my lord, your lordship has taken, my lord, elaborate notes, and then, my lord, it was adjourned. Then they started taking times. And, my lord, so far the applications are concerned, my lord, we filed, my lord, affidavit in opposition in connection with those applications. And then, my lord, they have not filed the affidavit in reply. And, my lord, your lordship extended time one after, at least thrice, my lord. Then now they are making this kind of prayers. Well, this is an abuse of process, my lord. My lord, with deepest of respect, my lord, I pray before your lordship, kindly do not release this matter. Your lordship fix any date. And they are waiting, my lord. They have been waiting since 2016. Your lordship, my lord, has, my lord, in session of this, my lord, matter.
Yes. Lordship. Where is Mr. Ahmed? Ask him to come. You seek for adjournment. When the matter is adjourned, you are not filing affidavit in reply. On the other hand, you are. No, this is uncalled for. Mr. Ahmed, it was indicated by Mr. Roy that there are other matters, connected matters, which was dismissed for default. The first instance.
Yes.
After that, you come up with a CAN application. Affidavit in opposition filed. Thereafter, you seek for adjournment for filing reply. And now you say you release the matter.
No. But there are three.
In one of the matters, Mr. Bhattacharya has argued.
Yes. So far, motions matter concern, we don't want to let. So far, hearing matters,
No, how can it be segregated? The issue is similar. You have argued.
three matters, is already.
Mr. Ahmed, I wouldn't
As well
have
as, I don't want.
listed all these matters if the issues were not similar. Now, if you want to segregate that, what
That's the
would
whole
be
difficulty.
outcome?
The three matters, three hearing matters has been listed before other bench. Now,
How?
My lord, now this
page-
is ready for hearing.
As your lordship,
They
I
file any reply.
since
Are the replies ready?
your lordship is praised with the other bunch of matters and the hearing, there is a hearing bench, and the bench there is three matters has been listed before that bench.
But before
So
your
for the
lordship, there are
hearing-
28 matters. This is clear abuse of process. This kind of submission, I do not expect it from Mr. Ahmed.
Where is your reply?
It's very unfortunate, my lord. After taking up this matter for 10 occasions, my lord, and your lordship was, my lord, granted, my lord, time. My lord, kindly, my lord,
Yes,
consider the order.
I
One after
should
another.
not indicate that before other bench also, he is appearing, they are not the same
If you
question.
want to hear out the matter, then what about the CAN applications reply?
Motions,
Yes, one after the other, the adjournments have been sought for, but no reply is coming up. You say that you will not file reply, we will dispose of the CAN applications and regularize and take up the matter for hearing.
kindly fix the date then.
Then what about the CAN applications? You are not filing any reply to that.
I'll be.
Then
I'll
again,
trying
it will
to.
be adjourned.
The difficulty is that these people are reside in a remote area and not being able to contact with all of them. And it's a long pending matter of 2016.
So what purpose will be served by releasing the matter?
Yes.
No. Only the hearing matters.
It is not the fact that the matters are not being taken up.
No. I cannot say that.
Every 2 weeks, the
I
matters
cannot
are
say-
listed and these are being
I
taken.
don't say that. I don't say that there are hearing matters. I was trying to dispose of all those.
File
hearing
your
matters first.
reply or say that you will not be filing. Contact your client and come up with the information. If you are not filing any reply, dispose of the CAN applications.
Yes, ma'am. After disposal of the kind of application,
Then the all matters can be taken up. CAN গুলো কোন
Right.
জায়গায় আছে?
so far the hearing matters are concerned, should I
কোনগুলো CAN? 14
only hearing matters.
My lord, item
more. 14
serial number 14 onwards, 14 till 14 to 22.
14 to 22.
There are, my lord, applications which are pending, my lord.
একটা কাজ বলতো 14 to 22 টাকে অ্যাপ্লিকেশনস এর হেডিং এ নিয়ে আসুন ওই দিনেই বাকি ম্যাটার্স গুলোকে হিয়ারিং এ রাখুন
20 টা নেই। আচ্ছা,
হ্যাঁ
একটু তাহলে
14 টা ডাকো তো একবার 14 টা দিন 14 আইটেম নাম্বার 14
Kindly give us 7 days time for filing reply and fix the date as per your lordship's convenience.
Mr. Shamim Ahmed learned advocate 14 acre 14 to 22 in all the matters in some of the matters they said that they will not be filing any affidavit.
yes, that has been recorded, man.
Mr. Shamim Ahmed learned advocate for the applicant seeks 1 week accommodation to file reply. Let such reply be filed by the returnable date. Release this matter under the heading application. এন্ট্রিতে নেই কেন? আচ্ছা, ঠিক আছে। নেক্সট উইক, ঠিক আছে? Next week
No, would
under
you
the
lordship be
under
pleased
the
to let,
heading application.
would you lordship be pleased to fix a date for hearing of the hearing matters? Or you lordship will be hearing all the matters together
Together.
after disposal of the applications?
Next week রাখুন। The aforesaid direction is made peremptory.
Grateful, my lord, extremely grateful.
The matters from 14 to 22, excepting item number 20, will appear under the heading applications next week.
Ma'am.
The other matters will appear under the heading hearing.
And when after disposal of the application, when I'll be requesting lordship to fix as a date so that this can be
My lord, it
disposed.
was taken up on
Only because these applications
Yes.
were pending, that's why the other
Yes.
matters could not be taken up.
চেষ্টা করো।
ওই দিনে এই ম্যাটার্স গুলোকে হিয়ারিং এর লিস্টে রাখুন। হ্যাঁ, 19 the other matters will be listed under hearing and this matter will come under applications.
grateful.
প্লিজ বাবু 14 থেকে এক্সেপ্টিং 20 একই অর্ডার করবেন, দেখে নেবেন যে কোন না
আমার মোবাইল থেকে
আইটেম নাম্বার 5 yes
none of us were present.
I'm
he was to argue
My lord,
5 তো না yes Mr. Banerjee.
lordship, yesterday what I wanted to place before your lordship that only my limited argument to the matter is what is the urgency and whether court can interfere. Because I am really not looking into the legality of that document. Though my seniors and my counsel for the state has given an elaborate discussion that yes, it can be good, it is good, how it is good, I will not address the court on that. I will beseech my lord to only restrict our submission, adjudication and application of court's mind to the extent that whether court can interfere. Second, if court interfere or if court do not interfere, what is the repercussion? Whether the anomalies which they have shown is such in a nature and magnitude which can affect someone's right. If I can just demonstrate by 15 days no one's right is affected in a way which is irreversible or they will become a remediless. Court will interfere because we will not forget that court is today is testing a SOP. First, I will try to understand what is SOP and whether court can go to that level to touch a SOP or not. Because the relationship, the service relationship with the petitioners and the state will not be governed by this SOP, I must say. It will be governed by the rules and regulation of the service. So this SOP is only for the department to make a view. Surplus is there, surplus is not there, zero registration student school is there or not. It is a administrative arena where the state will try to see whether it can this be a possible way to reach to my object. So that today which they have come before your lordship is a document which is actually an instruction of a superior officer to an inferior officer. This SOP, I have to understand, it is an instruction of a superior officer to an inferior officer to act in a particular way. Yes. To act in a particular way
to reach an objective. Because executive is so first we have to test. Before we test the reasonability, legality of that SOP, first we have to test, does this breach any right of the petitioners available to them under statute or rules?
Yes.
So the test will be whether it touches their right or it abridges their right in the rules, statute, constitution, anything. If that is not, then it's a instruction by a superior to a junior. Whether court will interfere there or they have a locus standi to challenge is lordship to decide. To start, what is the meaning of SOP? Lordship, I will not go into the legal meaning of it. Let's understand the meaning so far as the Cambridge or Oxford dictionary talks about it. So if your lordship kindly see, আমি যা যা রিলাই করছি সব অগ্রতা তোমায় পাঠিয়ে দিয়েছে হোয়াটসঅ্যাপ করে। হ্যাঁ lordship, if we look at the word standard operating procedure, SOP, it's a noun in form. The usual, its abbreviation is SOP. It is usually used in US. The usual way of doing something, checking reference before, or in case of lending money, the procedure before. That's the Cambridge dictionary meaning of this word. May I hand over this to your lordship? So lordship, this is extremely a administrative function. Lordship is little marked with papers. So lordship, it is a procedural part. Now lordship, whether this administrative function has done by other state, because though we admit, they admit that national education policy, which follows from the national education, has not been that way adopted, but it argued by them that even then not admitted, you cannot do anything which is in contra to that. That's their argument. Whether you admit it or not, I will not reply that. I will reply it at a later stage. But let's see, the states who admitted it have gone to that extent of forming SOP or not. Lordship, yesterday I indicated, I found 4 states, Haryana, Odisha, Assam, and Andhra Pradesh. So the 4 states have done so. Now, if your lordship kindly looks into this, I am now saying that whether I am trying to demonstrate whether the act of my officers, is it so vibrant, so different from the constitutional angle, or it is completely an alien procedure adopted by. If it is, then court must look into it. Why? If I make a SOP that for disbursing mob, I will start firing. That the SOP my police commissioner is giving. Lordship must look into it because it affects human life. So now, lordship, we will see the substance of this SOP is to find out a object, whether surplus is there, someone is deprived of a facility, adjust it. Whether this was at all existent in our society prior to 2009, I would like to see that first. Today what my officers have done has done a new path, or it was a very known traditional method which they probably followed for more than 30 years or 35 years 30 years or 35 years. Their lordship will find এটা দাও কারো থেকে একটা এই বইটা নাও এডুকেশন ম্যানুয়াল ছিল তো যে দাদা এনেছিল না দাদা তুমি এডুকেশন ম্যানুয়াল এনেছিল না এই তোমরা কেউ এডুকেশন ম্যানুয়াল এনেছো
চাই বলো কি চাই
আমার ওই 92 সালের রুলসটা চাই 92 সালে if your lordship takes up volume 1
এটা দিয়ে দাও এখন একটু yes
no lordship kindly if your lordship comes to page 152 volume 1
yes
Lordship, this is a scenario of 1992 when I had no 2009 Act. It was only in a system of 1973 Act. Now, Lordship, now we will read 4.
Yes.
The council, if it consider necessary in the interest of the primary education in an area under the jurisdiction of the council, may transfer any teacher from one primary school to another which is in jurisdiction, keeping the view of the educational need and welfare of the children in general. The council may transfer a teacher from one school where there is a surplus teacher. Lordship, the first word coming here is the surplus teacher. Surplus teacher according to the scale in Rule 3 to any other primary school where there is a shortage. So, Lordship, this concept of finding out of a surplus and shifting him to a
Yes.
school where it is needed was not unknown to us since 1992. In 2026, we come up and say that this is not right, this is not good, how you have done is not correct. Lordship, today we are still in a position of finding out viability of that act. So this act which my officers started is not unknown to this educational system and the judiciary since 1990. So, Lordship, kindly see this particular provision is there in force for all the time. So, the duty of an officer to find out, to impart better education, who is surplus and whether he should be transferred is known to us from 1992. Then, Lordship, a council may transfer a teacher posted in a primary when, in the opinion of the council, his service may be utilized in a better way by such transfer to any other primary school within its jurisdiction. So, Lordship will see council within jurisdiction. So, the very concept was council within jurisdiction. Lordship, kindly turn back to page 48.
Yes.
Lordship, this is a chairman writing to each district, each circle. Lordship, yes. So, sub-inspector of all schools. So, that means the district-wise. Each district was given. And Lordship will find from 1992, the concept was each council. Now, Lordship may Four, a council may transfer a teacher posted in a primary school to any other school within its jurisdiction where the service of the such teacher are considered necessary for the smooth running. A teacher posted in a primary school in a circle outside the jurisdiction of Calcutta District Primary School shall ordinarily be transferred under sub-rule 1 or 2 or 3 to a primary school situated either in the same circle or in the neighboring area. A teacher posted in a primary school within the jurisdiction of Calcutta, the primary school shall ordinarily be transferred under sub-rule such and such to any other primary school within the jurisdiction of Calcutta District Primary School. The council may transfer a teacher from one primary to another primary if such teacher seeks for such transfer in writing, stating the reason therefore provided a approved agency. Now, Lordship, kindly see this. Lordship has questioned us why I asked for his option. So, there are two ways. When I am reshuffling for prioritization of my teachers, now suppose I send him to X place and I send him to Y place. Both are in difficulty because this is quite far from him. This is also quite far from him. But this place is easier for him and this place is easier for him. If I use my discretion, so then it goes he to this, he to this. But if I, along with my discretion, if I take their opinion, because they are also giving 1, 2, 3, 4 preferences. So in that case, I have to shift one teacher here, one teacher here. Instead of shifting him here and him here, it's better him to here, him to here. So I am going to shuffle. But even that shuffling should have a least impact on a student's teacher's life. Because if the teacher is not good in mind, he cannot impart good education to the student. So, Lordship, I also take their opinion. Has it fallen from your Lordship that one where you are taking opinion, one where you are not taking opinion? No. After the exercise, I will understand the visibility, how far I can go. If I found that every school have a deficiency, then I might have to go for a drive of recruiting teachers. Maybe this exercise can be done for not even 2% of the teachers. Everywhere deficit. So unless I come to this, I won't be able to find out where I'm standing. Now in finding out this exercise,
Yes.
the teacher who are serving with me, they come and complain that if you do your administrative function like this, I will be prejudiced. What is the case? This is what I'm trying to do. This is what a man is not unknown to. So, moment I do it by a way of an SOP, which do not supersede any rules or any statute, a teacher who is in services comes back to a Lordship and say, if the executive functions like this, tomorrow I will be prejudiced. So immediately you stop his administrative function. So Lordship will step into administrative function to say, this is a wrong action you are taking today. And this action is irreversible in nature. Like giving a direction of using firearms for disbursing a mob. It cannot be reversible. So Lordship, today why they are asking a stay ex parte or an ad interim stage. While we grant stay in a ex parte or in an ad interim stage, we have to be extremely cautious that the entire process is irreversible. Yesterday, I tried to demonstrate from the language of the writ petition, so far where I am appearing. There is no such thing. He said discrimination will happen. Disturbance will happen. And between two persons, there will be some problem in doing this.
But there is another aspect to it, is we are dealing with Birbhum and North 24 Parganas. But the other districts have not prepared in
Nadia, I am appearing for Nadia.
Nadia. other districts have not prepared.
Yes,
Now it is coming from the district inspector of all schools,
yes.
not
It will
from
come.
any central department of the government asking to prepare a SOP. If you have gone through the Commissioner of School Education's letter dated 10th July, he just indicated you follow RTE.
True.
So far as Rule 3 is concerned, there is a provision that each school should follow RTE.
I would.
So now the question comes,
I was going to address your lordship on this.
now my question is, if government centrally an SOP is prepared, which is vetted, and thereafter it is distributed to the district to find out and identify the
True,
surplus.
true.
So one Howrah will take a decision of SOP, which will not be in consonance with not 24 Parganas, and also not in consonance with the Birbhum and all. So you have different SOPs for different primary school teachers in districts.
No, that will not happen. I will explain.
Just I put
Yes,
further.
yes, lordship.
Yesterday I put a question that revised as well as the earlier one, there are different principles which has been applied so far as identifying the surplus. So someone comes within 31st July, files an application or gives his option, the principle that is applied is different to someone who is going to apply within 6th August. So if this is not work out and the principle is not applied equally to all the primary school teachers, how do you say that it does not discriminate?
True. Lordship, I will not say it is. That's what I said, Lordship. I am not addressing it is discriminating or not. I will see it later. I will first see its effect of it. Lordship, kindly see. This might so happen. This SOP, and we have given to some district, because it might have given to other district as well. I am not aware of. They are not aware of. They are from a particular district. I am from a particular district as well. So I am restricted to a brief. They are restricted to only their district.
Yes.
So even today, Lordship do not have that holistic view whether everyone is doing or only 3 is doing. Whether every other districts are affected or only this district is affected. Then Lordship is drawing a presumption other may not doing. So yeah, that's what I'm saying. So other may not doing or may be doing. Complaint has not come to your Lordship. Maybe we are doing. So these are the facts to be brought before your Lordship by us. That's what my senior counsel and the standing counsel for the state said so. So Lordship, we have to show, because they are saying it is discriminating. One district is using earlier one, other district is using latter one. So we have to bring the entire fact before your Lordship. But today we are struggling from the state side, state respondent, that we are trying to show this has not emergency for which you will knock the door of the court. What Lordship said, maybe one has prepared with that SOP, earlier SOP, one district done with the latter SOP. Let's proceed with like this. So how do I presume that the head or the centralized body will accept this too? He might say, no, yes, it was my fault. I have given you the old one. You kindly revise it with the new one. So that's why I said, when the executive is in action, can a judiciary oversee him like this? That yes, you are doing this, it has to be good in every steps. It might so happen that 3 steps are bad on me. Then I realize my mistake, I recover it. So it's not an investigation monitored by court. I am doing certain act. Might be good, might be bad. Court will only see whatever you are doing, your administrative action, let it be. It might so happen after getting this, we find that out of 10 districts, 3 districts has used the old SOP. One has used the new SOP. So we will say either we follow this or we follow this. So we will bring uniformity. State, it is expected act of the state is rational. What here the case is, the presumption of this case is, act of the state will be irrational. It's a presumption. But under law, the presumption is otherwise. Presumption is it will act rationally unless proof contrary. So today what we have able to show to your lordship from the petitioner side is, see, this R with 3, this might lead to. Lordship, today when lordship is passing an ex parte order or an ad interim order, lordship has to satisfy himself that this is going to happen. Where is that starter? Where is that averment? All right, I am doing for this Nadia district, writ petitioner should come. I have come from the Nadia district. They are following the SOP of the old one. And the other district next to me is South 24 Parganas, is following the new one. I have taken information. One of my colleagues is working there. That averment should be there on the record. Someone is saying that you are doing this, but I don't know. The executive might use this one or that one, so there will be a difference. That's the case they're playing. They are placing their case in a very oscillating state. They have not a definite case that yes, they are using old one to me, new one to him, so there is a dispute. They say old one to me or a new one to me, and what will happen to him, I don't know, so I am knocked the door before him. So that's why, my lord, I was beseeching your lordship to look into from 3 angles. Once, this concept of overseeing is not unknown to us since 1992. Other state has done so. And today we do not have the record to show that yes, this will lead to this. Even if we take up the matter from 1 to 6, mine is one district, another in another district. Lordship, there also it is not evident that everyone is not following the same. Or in future, they will not follow the same. So each circle I have found. It might so happen where are 2 discriminations. Now, lordship, kindly turn to page 163 of the volume 1. Lordship, before I take volume 1, 163. My lordship, volume 1, book.
Oh, yes. Yes.
So, lordship, kindly see now 2002 rule, which they have also annexed. Lordship, kindly see. Then the role strength of a teacher, rule 3. Then, lordship, then rule 4, condition for transfer.
Yes.
Rule 4A is of its own motion. 4A is on motion. Now, moment we say own motion, then lordship, it comes 10. If we read 4A, then 10. So my SOP will lead to 4A. Does my SOP says that if it leads to 4A, he will not get 10? Is that the case they made out? If they are making a case that this SOP actually takes away my right under 2002 rules, whatever I do by my SOP with my offices, end of the day I will give a order. My all orders are subject to 10. Now, lordship, kindly see proviso of rule 4.
Yes.
Provided that the council may it consider necessary for proper utilization of a service of a primary teacher in the interest of the education, transfer an approved teacher without maintaining any time limit of service. Lordship has got it. So this says that The time limit of 5 years was there before someone can seek transfer or I can do transfer. But if I need a better utilization, then it can be done without going into that timeline. That means,
Yes.
now if I read 1992 rule and 20 years after 2002 rules, what enumerates for that is utilization of the teachers, irrespective of 2009 Act or not, betterment for the student is always permissible. Next proviso, provided further that where there is a surplus teacher, Lordship has got, according to the roll strength as stated in Rule 3, the council may, on its own motion, transfer such approved teacher without maintaining any time limit of service by way of a rational adjustment of teacher in primary school having deficit teacher in the following order of preference. So, Lordship, this SOP is not dehorse any law. I am trying to show that my object of my SOP and the object of this. So the rules are there. This is no one's case. These rules are not in force. The rules are there. I have to abide by the rules. So I made my own administrative act that this is how I want to know. If I make a committee of 3 officers, they have to understand from the statistics. We all understand from the statistics. So what they are trying to halt is, I'll kindly see the ulterior motive of them. They want to clinch to their own place. So for their own interest, they are trying to find out some fault in the administrative action. Transfer of a service, my lord. It's not posting him to Kargil that his life will be risked and he is saved here. So Lordship, kindly see this 2002 rules, says him. Then Lordship, if I procedure of the transfer is Rule 5, and then the 10 comes. Now Lordship, kindly see page 48 of the writ petition. Rule 8 ta na porala. Lordship, kindly keep the rule and then kindly come to page 48 of mine. I'm trying to show my SOP and the way I want to implement my SOP is entirely in toto in line. Lordship, kindly see now rule 8 of the book and page 48. Rule 8. Rule 8 is inter-council transfer. Inter-council transfer. In case of inter-council transfer, the council shall follow the principal procedure board and this provision confined in this of this. So, Lordship, intra and inter, both I have shown it. Now the SOP is also in a direction of giving inter more preference than intra.
No. Inter second preference, then inter will be more preference.
Inter will be more preference within circle.
Inter is outside circle, intra is within circle.
ভুলি গেলাম তো
না না
আবার বল
ইন্টারটা হচ্ছে একটা সার্কেল থেকে অন্য সার্কেল
হ্যাঁ ইন্ট্রা
ইন্টার হচ্ছে একই সার্কেলের মধ্যে
inner inter. Lordship, kindly see page 48.
Yes.
Lordship, collection and submission of the transfer application for rationalization of this, prioritizing intra-circle rationalization. To maintain the educational stability, first priority must be given to rationalize surplus teacher internally within his respective circle.
Yes.
By deploying, transfer them to the deficit school located inside her circle. He is requested to strictly follow the such and such. Intra-circle preference first. Ensure teacher existing their preference primarily targeting different deficit school within the same circle. Inter-circle deployment will only be considered as a secondary step where intra-circle adjustment is not feasible. So, Lordship, what I'm doing now, Lordship, kindly see what is the range. Now, kindly see what is the range. Now, if I keep him within intra, and I'm saying that outside your jurisdiction, I will consider the second. So, I will prepare a list. I will see how much deficiency is there here and there. Then, Lordship, I will implement it after rationalizing it. So they are not saying that you should not make the list within the circle, because why? What is the radius of a circle? It cannot be more than 15 kilometers. I'm sorry, maybe the diameter is 15 kilometers, radius will be less. So, Lordship, the area on which he might. So, what I wanted to show that even for my fault, what he has to suffer. It's not like that he is working here and I will shift it to some other place. His circle within, maybe if a teacher 10 kilometers beside, there is no teacher, so he might go there. Then also I am giving you in preference. Then this administrative function of me can come under judicial scrutiny. And can he say that give me a ex parte or ad interim stay? There I am. He has to come with that case that no, I will want a ex parte or ad interim stay. Where the state councils are saying that we will come back within 10 days, 20 days with all informations. So he has to make out that case. And I show that from the annexure, it is shown that the intra-circle preference first. So he is not taking out of his comfort zone, maybe little comfort, for the purpose of obtaining an object of ensuring students' education. A teacher. Yes. Now, Lordship, if your Lordship kindly turn to. Now, Lordship, kindly turn to page 537. Headmaster ta baad dewa joda bole. हाँ same book. Same. ওই টিচারটা কনসিডার করা হবে, টিচারের নামটা কনসিডার করা ছিল, অ্যাসিস্ট্যান্ট টিচার ইজ অলসো কনসিডার. No.
Yes.
Lordship, this is the West Bengal Service selection of appointment of the post of the headmaster, headmistress. Lordship, they have taken a point that the headmaster has been left out and a special teacher has been traced out. I'm going one by this point. First, I have shown that this is inter. Then they have taken another 2 points. Then the special teacher should also be considered as one of the teacher for purpose of maintaining role. That's their case.
Within the PTA.
Within the
PTA. Ground 10.
So they have taken a ground that even a special teacher has to be there in the role. If your Lordship kindly take up their ground 10, page 35 of the writ petition. Kindly see. They have not left anything unturned to skip their comfort zone intact. I will show this. Judgment.
Yes.
Lordship, kindly see, for that, there must be one special educator for every 10 child with special need people in every school as per RT. In the school number 4 mentioned in paragraph above, there are 4 CNA students and 1 special educator. Special educator has to take a regular class in the classes where there is no student, people belong to such and such. But the special educator is not taken into consideration for determination of computation of surplus. The teacher and the deficit school and teacher. There is no reasoning as to why special educator is not to be taken into consideration for determination of computation of surplus and deficit school teacher. This is arbitrary, illegal and malafide. Lordship, this is the stand that he has to take into. So they said that he has to take because he also has to be transferred and not taken. That's arbitrary. That's their law. That's their ground. Now I will show to your Lordship in 2021, not 22. Lordship, in 2021, Supreme Court had decided this. That when you are doing this monitoring, because this is not first time happening in my state, it has also happened in other states. So Lordship, when you are doing this, you should not touch that teacher in computation. Lordship, I am giving that citation that this ground do not hold like a citation. No. 2000
2021 17
2021 তোমাকে পাঠিয়ে দিচ্ছি তোমাকে কপি দিয়ে দিচ্ছি প্রিন্ট আউট করে নিও আমি সুবিধাকে বলবো পয়সা লিখতে So Lordship, then I will be relying on 2021-17 SCC, page 1. Paragraph 1. No, Lordship. Now this categorically says that while you computing, cannot take them into account. This judgment is Lordship, the relevant paragraph will be 64, 65,
67 and 67.
67. May I place that before your Lordship? Lordship, I could not take printout in the morning if your Lordship kindly takes it.
Yeah.
Sure. Be it be noted that the ratio of the pupil teacher has been mentioned in the stated scheme beside the norms and standards specified in the Schedule 2009 Act. Indeed, the Schedule 2000 make no distinction between the general student and a general school and a special school. But the norms and the standards specified for the general school cannot be replicated for special schools, which are governed by the special law in respect of the right of a person with disability and schemes to be framed thereafter. The 2000 does not clarify the position that the Act applies to all schools, including the school admitting the child with a disability as defined in section, and gives equal and same right to such school to pursue free, quality, compulsory education in the neighborhood. It further provides children with a multiple disability and the children with a severe disability may opt even home-based education. The fact remains that the meaningful and effective imparting education, the training of CWSN, children with special need, different norms and standard ought to be followed for the purpose. The school concerned are obliged to create a post of rehabilitation professional special educator coming to the number of CSI given. Somewhat similar situation was also pursued before this court in the state. Now, Lordship, kindly turn to paragraph 67.
Yes.
As a stopgap management until the competent authority formulate a comprehensive action plan including to specify the norms and standard regarding the pupil-teacher ratio to be maintained by the school concerned, imparting education to CWSN. We are pursued to adopt the pupil-teacher ratio ascertained in this decision as 8:1 for the total with the cerebral palsy, 5:1 for this ADHD such and such, and 2:1 for the deaf and blind, and 2 or more of the 7 disabilities such and such noted. Indeed, teacher to be so appointed need to be duly qualified, recognized, registered with the council in this. As regard to the appointment of the special such and such, the same may not appear to be a strict conformity with 25(2) of this. However, such teachers are not to be posted in a school as such, but are to be rendered their service in a cluster of school, which is permissible in context of this. The mandate in that CWN must be educated, trained only by the special teacher, being rehabilitation professional, duly recognized and registered by the council under this. The operation of these two act being Union Act. Then, Lordship, may I skip some portion? Then, Lordship, as a matter of fact, 2009 recognized the special treatment needed for the children such and such, which is not only recognize the right of CWSN to get free quality such and such, opt for the home base as may be. What is the absent in 2009 is the modification of the norms and standard originally specified in Schedule 1 applicable to the general school. Later in 2012, Parliament realized the need to amend 2009 to expressly include this. It should have been made corresponding changes in the Schedule 1 to provide such and such. Dispense with the general school admitting say and such, special catering to this. This would be done by the appropriate authority by amending such and such.
Age 67 rupees only, they have fixed stop cut. As a stop cut, they have recommended the ratio that is to be maintained. As general school ratio is not to be fixed with CWS.
Where is that paragraph?
Lordship?
Where is that proposition you said that?
Proposition, I said that is para 70, 67, Lordship, which says that this is a special ratio to be maintained for them.
As currently the school ratio is present.
As since this act do not specify any ratio for them, so they cannot be come into this pool. Their pool has to be different because the ratio is different for them. Lordship, I just shown the ratio, Lordship. Ratio,
67.
67 is the ratio, Lordship.
Okay.
So, Lordship, what I wanted to show is their ratio is completely different. They can't come to this ratio. And the stopgap arrangement is made by the Supreme Court. In 2021, the Supreme Court has said that they cannot because their ratio is different. Now, I can't compare an apple with an orange. Their ratio is different. So, I have to make a separate provision for them. I will take that Supreme Court ratio in my hand. I will make a separate SOP for them and then I might do a shuffle. But then they had this ground number 10. They said, why those special teachers are not taken into this pool? That was their simple question. The answer to this is para 67. They maintain in a separate ratio, so they cannot be taken in this ratio. So the Supreme Court has given that guideline, Lordship.
Yes.
Assistant teacher ব্যাপারটা কোথায় ছিল? Who is the assistant? দেখো না।
670.
Now, Lordship, kindly see page 619 of volume 1. Why I am trying to show? I am trying to show my SOP is not in violation of any of the rules which they are enjoying. Lordship, this West Bengal School Service Commission General Transfer Rule, Lordship, there, Rule 4. Three, 2 and Rule 4.
Yes.
this Lordship 3.2 and Rule 4 is not violated. That's not their case. So what he said, that impediment will come on him, hardship will come on him. So that is not their case. They have not made out that by this SOP, my General Transfer Rule 2015 will be breached. A man who is otherwise normal, he gets that 2002 rule and protection of 10. Otherwise, a man who comes under Rule 4, that spouse died, he has to take care or she has to take care of the children, or carcinoma diseases, all those, that is also there. So once 2002 is there and 2015 is there, then he is protected. Then he cannot ask me, don't exercise right now. And that too I have indicated that I am doing within the circle. So your risk is driving your two-wheeler 5 kilometers more. That's all. This trajectory they have made before the court is this is violative, this is violative. No, I have not done. So the main two violation, what he said, is the discriminatory in nature, because one teacher I am not calculating. I have given that has a special ratio I have to follow by Supreme Court judgment, so I am not doing.
Yes.
Andhra. Only one court in the Allahabad. So Lordship, Allahabad, only one court has, I have researched this, only one court has touched SOP to the extent where it says the recommendation can be made by the MLA MPs. The Orissa court deleted that portion. Finally, he said you can do it for your purpose, but not on the recommendation of the legislative members. So accept that. So accept that there is nothing. Now, Lordship, may I hand over another judgment?
Citation वाला दरकार नहीं, judgment को citation दरकार है.
Yes.
Lordship, kindly, paragraphs?
Paragraph number 115 onwards.
Lordship, if your Lordship kindly come to page 115, Lordship.
Yes.
The issue is not of a non-existing procedure, which I try to demonstrate, but of non-compliance therewith, where a specific mechanism exists, but it is not scrupulously followed, and resulting action become vulnerable to the judicial scrutiny on the ground of arbitrariness and violation of Article 14 of Constitution. Administrative expediency cannot be permitted to override the procedural discipline. The state government, in exercise of its statutory and administrative power, has consistently issued the government order and circular from time to time for the purpose of implementing the provision of such and such, with due regard to the large public interest and overriding effect, the safeguarding education and welfare of the students. It is also required to be noticed that time to time several government orders has been issued for implementation. However, the frequent issuance on the modification of such government in absence of reliable and update data regarding the surplus and the deficit teacher in primary had led to administrative disaster. The resulting uncertainty has been compelled to approach this court repeatedly, whereby given rise to wardable ground of litigation. So, Lordship, what I wanted to show is, whenever I don't have the complete data, every time the litigation will go. If your Lordship stops me today from my executing this, because they have their right under Section 10, they can, all transfer order will be challenged. Then Lordship will look into that transfer order. Lordship will see that this is discriminatory transfer order because you not followed, and Lordship will set aside. He will remain there. But if your Lordship do not allow me to exercise today, even in absence of my enter statistics before your lordship, then lordship, my state will be paralyzed. I never be able to get that data, who is surplus where. Because I have to find out who is surplus where. If I really want to make change in my education system, lordship, this has to be done. Otherwise, today I don't know how much requirement I have for my teachers. Lordship, this will also give me an idea, a fair idea, how much recruitment I have to do. What is my projection from some?
Yes. What is the citation of this you have given?
Yes, Lordship, his citation is WRIA. Lordship, I will get the court order of this. WRIA 179 of 2026.
Allahabad High Court.
Allahabad High Court, Lordship.
So, division.
Writ appeal. Lordship, it was a writ appeal.
Okay.
No. Sorry, my lord, this was single bank. Single. So, Lordship, what I just wanted to say is,
এটা দিয়ে দিন তো।
listen up, taking point. Listen up, point. Lordship, the last which I will show, 1993 4 SCC. 1993
paragraph 357.
paragraph
6 and 7.
না তোমাকে অনেকগুলো পাঠিয়েছি আমার পুরো রিসার্চটাই তোমায় পাঠিয়ে দিয়েছি দেখাবো
Page number?
yes
What is the page number of the citation?
lordship page number 357
Yes.
page number 357 paragraph 1
Paragraph 6 and 7.
lordship, from here I wanted to show, which I tried to argue, that administrative actions or my administrative direction to my subordinates may not come within the format unless it's resultant and they can show that really, like,
Yes.
they can really show that it will lead to overreach the rules and statutes. They are only arguing is discriminatory. It might lead to a situation. This is not their case that this provision is in violation or it's superseding my right under the statutes or rules. Now, Lordship,
This judgment has been followed in the
all right. Paragraph 1.
paragraph 6 and 7.
Lordship, may I read paragraph 6 and 7? An order of transfer is an incident of government service. Lordship, may I say that this was relates to a central service, but I am trying to take the analogy that when there is a transfer, how much a person can have a say in his own transfer, that too in my case within this. This is central service. So court said that once you joined a central service, then it is your duty to serve any part of the country. Similarly, here I said that once he joined a particular circle, then Lordship, within the circle, whether can he have a say to that extent. An order of transfer is an incident of government service. Fundamental Rule 11 says, the whole time of a government service is a disposal of the government which may pay him such and such, employs such and such. Fundamental Rule, the president may transfer the government service from one post to another. That the respondent is liable to a transfer anywhere in India is not in dispute. It is not the case of the respondent that the order of his transfer is vitiated by malafide. Vitiated by malafide, or malafide is on the part of the authority making the order. Though the tribunal does not so merely because certain guidelines issued by the central government are not followed. With finding this, the respondent attribute mischief to the intermediate superior who had nothing to do with this transfer. All he says is that he should not be transferred because his wife is working in such Shillong. The children are studying there and such and such health suffer a setback time ago. He relies upon certain executive instruction issued by the government. This instruction and nature of guideline. They do not have a statutory force. So, Lordship, what I am saying is, this says, then who should be transferred where is the matter of the appropriate authority to decide. Unless the order of transfer is vitiated by the malafide or is being made in violation of any statutory provision, The court cannot interfere with it. While ordering the transfer, there is no doubt that the authority must keep in mind the guideline issued by the government on the subject. Similarly, if a makes a representation with respect to his transfer, the appropriate government must consider the same, having regard to the exigency of the administration. The guidelines say that as far as possible, husband and wife should be posted in the same place. The same guideline, however, does not apply confer upon the government employee a legally enforceable right. So, Lordship, what we know that husband and wife should be posted in the same. So, their court said it's not a legally enforceable. So, what I am doing is an SOP to find out my own status. Now, Lordship, he cannot come and say, because of your, then tomorrow he might say that one of your employees is not working or he is not signing, so I am affected by that. That cannot be. My administrative service I am doing in an administrative category, and Lordship, that result, he has his protection under the rules.
Probably this judgment will not apply to the facts of this case because no transfer order has been issued.
No, what I'm only saying is just to show this two paragraph to take a relevance that when, because then ultimately what he says that end of this SOP is a transfer. End of SOP is a transfer. I said that the transfer is within your circle. Second preference is outside circle. So what he says, this the entire alimony will happen while transfer. That's the gist of his fear. So what I say is, when you joined a service, the transfer is a matter of policy.
Oh. That's all.
If it does not,
এটা কি আজকে দেখা হয়েছে বললো বলো ঠিক আছে মানে just one more judgment, one more. I will not read the entire judgment also. It is 2006-10 SCC, page 337. Others. Piyush, देखी दीजिए. Piyush, देखी दीजिए. Lordship, this is, I am also relying on that, my learned seniors.
What is the page number of this?
The page number is 337, madam. Para 11. Piyush the relied.
This is with regard to the administrative action.
Yes.
That's
Sanyal starts. Mr. Sanyal starts.
মানে শেষ করতে দিবি না মানবো নাকি পলিসিটা বল তাহলে this is the policy then well it takes me to the second half but again I have a second half a fixed matter
5 minutes. That since state has not yet concluded its argument, Mr. Banerjee was on his feet. Lord, one issue which Lord repeatedly Lord was troubling all of us, and it fell from your lordships as to what is the criteria for bringing in by way of the revised SOP 7D, the biological age. Lord, it was also haunting me. Lord. I came across, Lord, a judgment of the Punjab and Haryana High Court, where, Lord, in an identical situation, while framing the transfer policy, Lord, the government, Lord, fixed, Lord, marks for, among other, also for age. Lord, more the age, more the marks. But the juniors, they may not challenge the proceeding before the Honorable Lord High Court. But the High Court may not held that it is for the employer to fix up a criteria. Now, those who are younger today would invariably get older in service tomorrow and may reap the same benefit if a situation so arises. But this fixation cannot be held to be arbitrary. Lord, having found this, Lord, I thought that, my lord, it may fit in, my lord, in the present facts and circumstances, and may answer, my lord, the query that fell from my lord, which, my lord, until now, my lord, none of us, my lord, could address my lords, my lord, on that. Kindly permit, my lord, only to cite that judgment and, my lord, read the relevant paragraph. I shall not take more than 5 minutes of my lord's valuable
এবার
time.
সাইড করবি হাউ ডু আই ডিল উইথ ইট তুমি রাত থেকে দিয়ে দিলি না কেন
Well, I have an
আমি
answer.
হাউ ডু আই ডিল উইথ ইট
I have an answer. I have an answer to Mr. Sanyal.
কি জানি
The last post that came from Mr. Sanyal's junior was when the calendar has altered its status yesterday night, saying that they are going to rely on these documents.
দ্যাটস ওয়াই আই হ্যাভ সেন্ট ইউ
Yes, when the calendar has already altered its status.
Well, our calendar starts after 3 p.m. in the morning. 3 a.m. So it's normally for the lawyers.
This is continued. It will continue.
তাড়াতাড়ি কর না তাড়াতাড়ি কর না আমি শেষ করতে পারবো Weekday. না না যেন অর্ডার চাইছি না হিয়ারিংটা কন্টিনিউ করতে চাইছি it goes on like this
Lord, this is Lord 2025 SCC online,
বার করে
Punjab and Haryana 2862.
people.
2862.
Yeah.
Airdrop kar dena. Lord, kindly seize, my lord, paragraph 3. The petitioners are working as subdivisional engineer civil with respondent Haryana State Agriculture Marketing Board. They have joined respondent on different dates and are posted at different places. In exercise of power conferred by proviso to Article 309 of the Constitution, the Governor of State of Haryana made online transfer policy on the 13th February 2020 for the government employees. The said policy was a model policy. As per clause 2 of the policy, it would be applicable to all employees of a cadre working on regular basis, where cadre strength of a post is 500 sanctioned posts or above. By subsequent amendment is what made applicable to posts having cadre strength of 80 or more. The cadre strength of SD in the department is less than 80. The respondent, taking cue from state model policy, framed its online transfer policy dated 15 June 2023. The said policy was approved by different officers at different level. Then next line is not important. The petitioners are feeling aggrieved from few clauses of the online transfer policy dated 15th June 2023 on the ground that these clauses are arbitrary, thus violative of Article 14 of the Constitution of India. Then Lord Mr. So-and-so, advocate for the petitioner, submits that as per the impugned policy, the respondent has laid down criteria for calculation of scores. On the basis of score, an employee is posted at a particular place. 60 marks are earmarked for age. Higher the age, higher the marks. Resultantly, the younger employees are not likely to get posting of their choice. Lord, I pause here for a moment, Lord, and then take my lord directly to paragraph 7.
Yes.
The petitioners are assailing the policy on the ground that its clauses are arbitrary. For ready reference, the relevant clauses of the model policy dated so-and-so and impugned policy dated are reproduced below. Lord, kindly let's come to Lord the subhead 5 with the title Merit Criteria for Allotment of Post. Lord, kindly sees Lord, merit for allotment of vacant post to an employee shall be based on total composite score of points earned by the employee out of 80 points as described below. Lord, kindly see Lord B, age shall be the prime factor for deciding the claim of an employee against a vacancy, since it shall have weightage of 60 points out of total points. Lord, kindly, Lord, comes to paragraph 8. It is a settled proposition. I'm sorry.
Yes.
Paragraph 8. It is a settled proposition of law that scope of interference in policy matters is very limited. The persons who are making policy are more competent to know need of the people as well as the need of the organization. Honorable Supreme Court has time and again adverted with the scope of judicial interference in policy matters. A constitution bench in Vivek Narayan, while adverting to so and so, then Lord, kindly Lord, permit me to read Vivek Narayan, only 2 paragraphs, Lord, which are taken note of. Paragraph 218. The law with regard to scope of judicial review has been very well crystallized in Tata Cellular. In the said case, it has been held by the court that the duty of the court is to confine itself to the question of legality. Its concern should be whether a decision-making authority has exceeded its power, committed an error of law, committed a breach of rules of natural justice, reached at a decision which no tribunal would have reached, or abused its power. The court held that it is not for the court to determine whether a particular policy or particular decision taken in the fulfillment of that policy is fair. It is only concerned with the manner in which those decisions have been taken. After referring to various pronouncements on the scope of judicial review, the court has summed up thus: the principles deducible from the above are the modern trend points to judicial restraint in administrative action. The courts do not sit as a court of appeal, but merely reviews the manner in which the decision was made. The court does not have the expertise to correct the administrative decision. If review of the administrative decision is permitted, it will be substituting its own decision without the necessary expertise, which itself may be fallible. And then, my lord, the 6, subnote 6, quashing decisions may impose heavy administrative burden on the administration and lead to increased and unbudgeted expenditure. Based on these principles, we will examine the facts of this case, and they commend us the correct principles. Now, my lord, your kindly, my lord, comes to page 7. My lord, small scale industries case, my lord, 2011, volume 8, SEC, page 511, my lord, is relied upon. My lord, I only, my lord, read, my lord, 2 paragraphs thereof instead of, my lord, citing this judgment, my lord, independently. My lord would kindly come to page 8.
227.
My lord. No, my lord, page 8, paragraph, my lord, subparagraph 71.
71. Yes.
The correctness of the decision which prompted the government in a decision taking one course of action instead of another is not a matter of concern in judicial review, and the court is not the appropriate forum for such investigation. The policy decision must be left to the government, as it alone can adopt which policy should be adopted after considering of the points from different angles. In assessing the propriety of the decision of the government, the court cannot interfere even if a second view is possible from that of the government. Lord, I pause here for a moment. Lord, this argument, my lord, I made before your lordships, and my lord, I relied upon, my lord, 2006 Supreme Court, that a second view may be possible. But merely because a second plausible view is possible, my lord, if the court would not, my lord, interfere with the first view taken by the administrative authorities. Then, legality of the policy and not the wisdom or soundness of the policy is the subject of judicial review. The scope of judicial review of the government policy is now well defined the courts do not and cannot, as an appellate authority, examining the correctness, stability, and appropriateness of a policy, nor are the court advisors to the executive on matters of policy which the executives are entitled to formulate. This court, in Small Scale Industries Manufacturing Association, observed that the court would not interfere with any opinion formed by the government if it is based on relevant facts and circumstances or based on experts' advice. This court would be entitled to interfere only when it is found that the action of the executive is arbitrary and violative of any constitutional, statutory, or other provisions of law. It has been held that when the government forms its policy, it is based on a number of circumstances and it is based on experts' opinion which must not be interfered with, except on the ground of palpable arbitrariness. It is more than settled that the court gives a large leeway to the executive and legislature in the matter of economic policy. Now, that kindly comes to paragraph 15. Petitioners are also claiming.
Yes.
The petitioners are also claiming that the impugned policy is contrary to the model policy and there is no source of policy. The transfer is an integral part of service. Every employer has a right to frame its policy. In the absence of policy, the employer has a right to place its employee as per its choice. The respondent, by making impugned policy, rather has attempted to create an atmosphere of transparency. Lord, with these observations, Lord, the court, Lord, has Lord, declined to interfere when Lord, biological age, Lord, was made a criteria. Lord, today the position is like, Lord, there are rules, Lord, which are taken recourse to, and Lord, 4A and 4B are in place. We find that there is a disproportionate anomaly insofar as availability of teachers are concerned. A process of rationalization is being undertaken. This rationalization may result to some displacement in the form of transfer, but then my lord would look into it from this point of view as to whether Milord, the authority, Milord, is denuded of the power to at all undertake such an exercise or not. Milord, at the risk of repetition, Milord, I say that, Milord, I have shown to my lord that even the transfer rules, Milord, 4A, Milord, they embed, Milord, the authority with the power, Milord, to transfer on its own motion. The process of rationalization would be, Lord, therefore taken to be a process, Lord, in exercise of 4A. But when, Lord, the convenience of the teachers who are found surplus is being taken, then we are also, Lord, taking into consideration 4B, which is, Lord, at the instance of a surplus teacher, transfer being effected. Both, Lord, conjointly are forming a part of the SOP, and Milord, this SOP, Milord, is being given effect insofar as item number 4 is concerned. Milord, is being given effect, and we have ascertained, kindly see, Milord, the anomalous situation which exists. My instructions are that there are 4,052 surplus teachers.
Number item is in fact
52. Good.
বলে হ্যাঁ আরো যেটা দরকার সেটাও বলছি
Not taken.
page number.
No, these are instructions, will not I say.
Okay.
There are 4,052 surplus teachers.
Not 20. Not 24.
Well, my learned friend would have the complete data in respect of not all districts. Lord, insofar as North 24 Parganas is concerned, Lord, the surplus status is 4,052. And the deficit vacancies,
এটা কি সারপ্লাস টিচার না স্কুল?
and the deficit is 1,962. 1962.
টিচার
Now, kindly see, my lord, even if, my lord, this exercise is undertaken, yet, my lord, we remain with, my lord, about 2,000 surplus teachers. In such a situation, if we are not permitted to rationalize, the imbalance, my lord, would be disastrous, and the policy, my lord, as my lord sees, is taken in public interest. This public, my lord, would, my lord, within its ambit, bring in the teachers, the students, and the education system at large. Hence, my lord, I beseech your lordships, my lord, kindly do not, my lord, interject with an interim order which, my lord, stops the authorities from undertaking this exercise. If it comments to my lord that, my lord, this is spiked with certain, my lord, errors, my lord, corrigible measures can be, my lord, directed by my lords, but lock, stock, barrel, if the entire policy, my lord, is being stopped, then, my lord, this will, my lord, seriously hit, my lord, the steps which are to be taken in public interest, my lord. Those are my respectful submissions. I'm extremely grateful, my lord, granted me another opportunity.
But here, but also, but what I have asked, but I've handed over right now. But takes the second document first.
Mr. Chatterjee, please have it. Not judgment.
The second document first, but here the zero enrollment primary schools, but issue has been addressed. But zero in teachers in zero enrollment primary schools have been identified and transferred to deficit schools. Primary schools having surplus teachers, the figure is there. Malad wanted yesterday, Malad, which had fallen from Malad. Surplus teachers in primary schools, Malad, this is there. And SOP was first published, was modified, Malad, in subsequent SOP. Malad, will you need to take the second document, Malad, now? Yes. Malad, the one, I'm sorry, Malad, paper, Malad, here, Malad, take the front page, Malad. This is, Malad, July 2026. This is the memo number.
Yes.
Malad, with reference, Malad, the subject is rationalization of primary school teachers with reference to the subject mentioned above. The undersigned hereby requests to take immediate measure to rationalize primary school teachers in accordance with RTE Act 2009 on urgent basis by transferring teachers from schools where teachers are surplus as per pupil teacher ratio of the school to the schools where number of teachers are deficit as per pupil teacher ratio of that school. Is requested to transfer the teachers who are working in zero enrollment schools to the schools where number of teachers are deficit as per pupil teacher ratio. My lord, then, my lord, you'll be pleased to take, my lord, the next page, my lord. This is, my lord, the revised SOP which is being followed. My lord, this the D is there, my lord, and F is there. My lord, the portions which have been revised, my lord, have been marked in bold also. But in the original SOP which was sent. But not this.
This is the policy.
My lord, this is the policy which is being followed. My lord, the revised SOP, my lord, is being followed. My lord.
But then that has been annexed to the other writ petition that
My lord, that was not being followed. My lord, that
this is the person who comes last, he goes first.
Person who not yes. My lord, now it's the biological age.
But no, the SOP which you have handed over right now, you say that has been followed. It says that for consideration of surplus teachers, senior teachers in respect of date of joining in the present school shall be considered first.
Yes.
That means the person who comes last, he goes out first.
That was, Malad takes the next line, may be replaced by the following.
Oh, yes. So this is existing now.
Malad, that is what is there. But so there is no hide and seek, my lord. This is what was there. My lord, since my lord, the reasons also given that it is that there is no such provision in the existing rules. My lord, so the younger my lord, biological age, which my lord,
Okay.
my then senior my lord had. My lord, also my lord, the one logic my lord was pleased to take my lord route 4 my lord is taken. 4 my lord.
Why to face pitch?
4 A my lord was taken. Also there is a proviso
Both
to rule 4. My lord provided further that when there is a surplus teacher according to roll strength, the council may on its own motion transfer such approved teacher without
That he has argued, Mr. Banerjee has argued on that.
this will not. But also, my lord, if there was one logic, my lord, while we were discussing, my lord, this, my lord, they said, my lord, if there is a teacher in a zero enrollment school, that teacher will never want to apply, my lord, under 4B and want to be transferred himself or herself.
Then you exercise your power under 4A.
Yes, this is what we are, my lord. This is on its own motion, but this is something, my lord, we are. And this is a one-off time.
But there is another aspect which has come up when you was arguing that there are surplus teachers. Even if the deficit has been made out in North 24 Farganas, there are also surplus teachers.
But because
Data that has been given.
balance, my lord, which persists.
That also requires rationale. Yes, Mr.
My lord, prior to, my lord, in this matter, in item number 2, my lord, I am appearing for the, my lord, District Primary School Council, Paschim Medinipur.
Yes.
My lord, your lordship, yes, council is made party in the petition, kindly come, go through the petition.
As a body, we have.
Yes,
made it. Where is the
whatever
council?
the council is there.
Yes.
My lord, we are suffering being the council. My lord, regarding the, my lord, for rationalization of the teachers, student ratio in many schools, my lord, in the districts, in our Paschim Medinipur, under the jurisdiction of Paschim Medinipur District Primary Council, my lord, this PTR problem is, my lord, we are suffering a lot. And my lord, time to time, government, my lord, issued notification, and the latest notification issued by the government under the, my lord, power and authority under the RTE Act, where, my lord, it has been clearly stated in section 25(19), my lord, that this ratio of this PTR should be maintained strictly for rationalization of the teachers, because in our state, not only in my district, in all the states, my lord, the deficiency of teachers. And my lord, for this purpose, we have to look into the schedule mentioned in the RTE Act. Strictly, my lord.
Okay.
I
Do
can,
you have any new
my lord,
thing
I am coming.
has
Therefore, my lord,
exhaustively argued
yes,
on
yes,
behalf
it
of
is-
the chairman.
it is given. It is, my lord.
If
Now,
you adopt to that, any additional point is there?
yes, additional point, my lord, my point is that the, my lord, impugn notice is issued by the government, my lord. It is, my lord, under the RT Act, where, my lord, they have the jurisdiction to deal with the PTR, so that the pupil teacher ratio should be maintained in the schools. First submission, my lord, and they have the authority. Local body and the government shall see. It is clear from the, my lord, RTE Act.
Okay.
Now, my lord, our main purpose, that is the questions, my lord, as my lord has asked us, my lord, the learned lawyers. Firstly, I am adapting the submissions made by, on behalf of the, my lord, state government advocates, the senior advocate. I am adapting all these submissions. My point is that every day, my lord, we are here before your lordship, moving the transfer petitions, and in the said transfer petitions, my lord, in hundreds of matter, PTR point of PTR is, my lord, they are taking that point, that PTR is, we are surplus teacher. Therefore, this surplus teacher should be, my lord, these deficit teachers should be, my lord, rationalized. And this is the purpose.
Okay.
And for this purpose, this SOP has been, my lord, they have, my lord, the state government have, my lord, issued this SOP.
Okay.
This SOP, my lord, mostly, my lord, it has been, my lord, made on in consonance with the, my lord, in consonance with the, my lord, the transfer rules, which is, my lord, our 2000 rules, amendment rule 2021, and all this, my lord, transfer rules, it has been taken into consideration. And, my lord, some directives has been issued by the government so that this problem may be solved. And I pray before your lordship, my lord, your lordship kindly look into the matter that this people teacher ratio should be, my lord, maintained in the state strictly. And, my lord, I am praying before your lordship not to pass any interim order by staying this process. Because of that, schools are suffering, students are suffering, and your lordship, I pray before your lordship to, my lord, your lordship's inherent power should be issued in this matter. Because of that, this should be, my lord, meet up.
That's all.
This is my humble submission before your lordship.
But I'll be dealing with the submission of Mr. Chaturvedi in reply. In item number, my lord.
সেটাই বলছি কালকে ফিক্স করা
নিষ্ঠা দেবনাথ এটাই তো নর্থের my learned friend has taken the point of maintainability on the ground of absence of jural relationship, citing one judgment of our High Court. Now, my lord, I have taken one paragraph.
This is your reply to item number 4.
My lord, serial number I don't 4, item number 4. 4, man.
You are appearing only 4 or
I'm appearing only 4.
4? Yes.
Now, that paragraph I just take your lordships. Paragraph 39, capital A. Having the same cause of action, the petitioners have joined this petition. Copy though. Good. এখানে থাকবে জাস্ট মিনিট মানে অনেস্টলি জানো কাল যে বার করা হলো তুই নিজে কিছুই তৈরি হচ্ছিস না আমার ঘাট দিয়ে চালাচ্ছিস Namalot, kindly take up this judgment. 1973 SCC Online Gujarat 113. I will be placing only one paragraph. 113. Para 4. Only para 4, my lord, I will read. The practice which obtains in England requires a writ petition to be filed by one petitioner. It may or may not hold good in this country. However, where there are more than one petitioner having common facts to urge and raising common questions of law, for the decisions of the High Court in a writ petition, a common writ petition can be filed by them. Unless, therefore, all the petitioners who have joined in the writ petition have common facts to urge and common points of law to argue and common reliefs to claim, they cannot file a common writ petition. That's the settled law, my lord. I will urge, my lord, the jural relationship what is. Now, kindly have a look, all the petitioners are teachers under the North 24 Parganas District Primary School Councils. My lord, what they have urged? They have urged, my lord, the question of the so-called SOP. We have affirmed in the pleaded in the writ petition. This is non-statutory in nature. Now, my lord, I have, my lord, I am thankful to Mr. Chatterjee that he has handed up this document. No. That's set off like this. This is letter dated 10th July 2026, which is part of my petition, your lordships. And along with this, as if these are the part of this letter. As if this SOP. I will address on that, your lordship. But what I'm saying, SOP relates to identification of surplus schools and surplus teachers, deficit schools and deficit teachers. So, this process of identification we have questioned. We have not questioned the government power. But one should not misguide himself by saying that I am questioning the power of the government. I'm the last person to question the power of the government. Government has every power to do it. But who has done it? Does it have done, has it been done by the government? Does it appear from the SOP? This is the question. I will deal with it, Malad, in reply. So this is a common question by all of them. Now, Malad, suppose your lawsuit, this has been done by the government, your lawsuit hold it. Now, process of identification is there. I have shown, Malad, in paragraph 8, there are schools. I've given as an instance that's now fructified. They're admitting that. I will show from their list also. That in a school, out of 4 teachers, 2 have been declared surplus. So those 2 are petitioners. Or 1 is a petitioner. In another school, 1 is the petitioner. Surplus teacher stands in a footing en bloc. So they have the dual relationship with each other between the intercity teachers. So they are questioning the process, how you have labeled me as surplus. But I am never questioning the power of the government to declare me surplus. But what is the method you are following, Eva? Is it with reference to school or with reference to class? That's my basic point I asked. But I'm sorry to point out before lawsuits, none of my learned friends have dealt with it. They have avoided it to deal with it. Because this goes to the root of my matter. If it is in relation to school, absolutely wrong. If it is in relation to class, I will be out of the court. But I have shown, I will again show, this has been done with reference to the school. This is wrong. You might not have teachers. Your inaction, you cannot shoulder upon the petitioners. You ought to have taken first steps to appoint the teachers. Rationalization doesn't mean I have to, in a poor family, 1, 2 children, but they have 1 egg, you have to curtail it and give half and half. This is not the process, my lord. I clear to your lordships. In a poor family, the father cannot give 2 eggs to 2 children. What they have done? 1 egg they have cut, half you and half the other son. Are you following that? Here 8 surplus teachers, deficit teachers, here 6. So 1 reduce, give it to this. This shows your inaction, that you cannot appoint teachers first. That's come within the RT Act infrastructure. Providing sufficient teachers. You provide sufficient teacher first. That's why I've shown your lawsuits, the duty of the government first and local authority, section 6 and 8. You have not undertaken that duty. On the contrary, you are saying surplus, surplus, surplus. We are not surplus. So therefore, my lord, I have a dual relationship between amongst the petitioners. Now I will show one judgment. What is dual relationship? 2006 4 SCC. My lord, 2006 4 SCC, page 484, paragraph 21.
1 second. 1 second, kindly give the citation.
I'll hand up to your lordship. 2006 4 SCC, page 484, paragraph 21. What was it? আপনি মাথা কাজ করে Well, I have handed up 2006. May I take the pagination once? একটু just 484. Paragraph 21, I am taking your losses. But I will be, my lord, kindly skip over the first 6 lines and then, but I'll be very concise in making my submissions unnecessary the court's time goes. The term jural means legal. Got it, your lordships? Or pertaining to rights and obligations. Jural relationship between the parties means legal relationship between the parties with reference to their rights and obligations. That's all. We are questioning SOP. It deals with my right, the first petitioner. It deals with the last petitioner's right. They are covered by the so-called SOP. So this is their jural relationship. They are questioning that legality of that SOP before your lordships.
Okay.
And one more thing, my lord. So for the court fees are concerned, my lord, I'm undertaking to deposit the court fees of all the petitioners. Now, the second point I tell your lordships, we have raised. Now your lordships take up this documents Mr. Chatterjee has handed up. This is part of my petition. That's also paragraph page 162 that later. This submission covers Mr. Chaturbedi, Mr. Chatterjee, and Mr. Banerjee also. In regard to what's the urgency, what's the hurry in it? Well, this is a letter dated 10th July 2026 by the Commissioner of School Education to all the chairmen throughout the state, I find. Subject rationalization of primary school teachers. With reference to the subject mentioned above, the undersigned hereby requests him or her to take immediate measure to rationalize primary school teachers in accordance with the RT Act 2009 on urgent basis. On urgent basis by transferring teachers from schools where teachers are surplus as per PTR of the school to the schools where number of teachers are deficit as per PTR of that school. He or she is also requested to transfer the teachers who are working in the zero enrollment school to the schools where number of teachers are deficit as per PTR. Well, I do not find at least any reference to the SOP. Then where from the SOP comes, but I am putting to question myself. Who has issued it? I expected that state at least come forward and say that SOP has been issued by the Commissioner of School Education or Director of School Education or the Honorable Governor. Who? Well, it's a court of law. One has to say that this has been issued by the government. But which authority of the government, which part of the government? Well, state government, the Honorable Governor is the executive head of the state government. As I place the judgment before your lordships under Article 162, government can certainly do it. But one must take the responsibility before the court and say that I have issued it. And this is my authority under which I have issued it. As of today, your lordships, nothing before your lordships. And they have not replied against this. They have annexed it with this, as if this has been issued by the Commissioner of School Education. But if it is issued by the Commissioner of School Education, then it's a mere administrative instructions, non-statutory in nature. I'm again thankful to Mr. Chatterjee. It has been given to your lordships? Haryana?
No.
Well, yesterday they have given. They have handed up, Mr. Chatterjee, I'm told. Mr. Banerjee, or somebody from the state side. Can I have a look at it? Oh, but kindly see who has issued it.
Kindly see, this is the transfer policy.
Haryana transfer policy.
No, sorry. I gave transfer policy, but I relied on the prioritization.
Not that. This is before your lordships. Kindly have a look at the facing page of it.
No. He has not placed this.
Not placed.
He only argued that some of the states have adopted.
I'm giving to your lordships. Kindly have a look at it. Some references made.
This is transfer policy.
Kindly see the policy.
So please indicate it's a transfer policy.
Now your lordships, the SOP is a policy according to them.
No.
No, it's not policy. But I fail to understand because 3 learned councils are appearing. Who is what saying? Is it a policy or not? Is it a SOP or not? SOP is a policy. It's a matter of policy.
Procedure. I'm sorry, I'm sorry.
My lord, any standard of procedure means what? It's a policy of the government.
No, policy to implement policy SOP comes.
My lord, if your losses kindly will look at this, then
That
this
is,
is
that is
this
the why,
is
that is exactly the
but this is
reason
policy.
why I relied on the Cambridge
My
dictionary.
lord, I take your
But you
losses.
kindly see the Cambridge dictionary.
My lord, kindly will look at this. This is issued by the notification. Who issued it then? At least tell before the court that this officer has issued it. Nobody has issued it. Who prepared it? For a particular district. In another district, there will be another procedure. There must be certainty of it. I'm a teacher. I must be certain about my rights and duties and obligations. How do I determine it? Just because I'm employee, I do not have any right. How do you deal with it?
Sir, I'm sorry, I shouldn't have done this, but this is not his case.
My lord,
If your lordship
oh
kindly
my
see-
lord, this is my. I think this is not the way I am doing it. I've never interfered with.
Understand, but
But
this is where
kindly
you are
have a
saying
look
to
at-
the ground that this
My
is a
lord-
non-statutory, and then today you are saying.
Of course, you are producing it.
So
Your
that's your
lauded
ground.
junior
So
government
you cannot
advocate
run a
produced
new
it.
case.
My lord,
After I
how
gave
my
my,
lord, this has been produced before your lawsuits
Yes.
with the SOP. Then how can I not?
No,
It's
what
a
you
part
are
of the
arguing
record.
is not exactly what is there in your ground.
This is a maybe not ground. Maybe not ground. Court can do it. Court can look into it.
Taken a ground alternative to it.
Our
You said it is
alternative,
a
my lord-
non-statutory in nature. So I
Yes.
based my argument on that, sir.
Maybe you have. I am not addressing your argument.
No, you are replying
Now
mine.
that's your lawsuit that somebody had produced it. Kindly
Replying
have a look
my
at it.
argument, sir.
Who issued it? In the document, your lawsuits will not find it. Who issued it? Who issued the SOP? Then if your lawsuit is a simple administrative instructions, suppose accept it. If administrative instructions violates the legal and fundamental right, I can question it. That's settled law, man. Even an administrative instructions, if violates my legal right and fundamental right, or either of the two, I can question it. No judgment is necessary before your lawsuits. Citation of judgments comes fast. Your action takes away my right. Now I will tell Mullah what right you have curtailed. Now Mullah, kindly take up the SOP, first SOP, or both. Kindly see the procedure. Now the procedure, so far, this is primary schools, your lordships. All the procedures are not intended for us. Now your lordships will find. Kindly see. My lord, I have placed your lordships. So for scope, Roman 3. Surplus teacher identified in schools where staffing exceeds the prescribed norms of RTE Act 2009. So you are supposed to follow RTE Act. You are saying it. Now you will see procedure. Kindly see, my lord. I am skipping the first one, zero enrollment. Of course, you have to give teachers or you transfer the school. Identification of teaching and non-teaching staff, zero enrollment. I'm not questioning it. Identification of schools with surplus teachers. Identification of surplus teachers. My lord, how this is to be determined? My learned friend said this is procedure. How? Procedure must spell out that this is the way I have to determine it. Lord, I have not.
We are, Mr. Banerjee, we are faced with a similar problem which I indicated on the yesterday. This is item number 4. Now, 30th July 2026, the district chairman of the DPSC, he has annexed the SOP. He has forwarded copy of that to the Commissioner of School Education. Today, Mr. Chatterjee has placed this letter annexing the SOP. Now, the variance is that now he says that this SOP is applicable, that this junior most teacher should be transferred first.
Biological age.
Biological age. Yesterday, what I indicated from that letter dated 30th July 2026, that both the SOPs are being applied. Someone who comes and files an application or gives his option within 30th July 2026, the principle applied to him is separate. Subsequently, the
To which is annexed in my brief 49AB.
No, no, you can have a look to this, that the brief I am carrying. You have to দেখান তো।
Lordship, can you tell me which page Lordship is indicating?
163 only.
163 এটা লেটে যাচ্ছে তো এটা যাচ্ছে এটা যাচ্ছে এটা যাচ্ছে এটা যাচ্ছে পরেরটা and 166 is the amended one, right? Then 166 is the amendment. One is the post amended, one is pre. Now, Lordship, kindly compare this two. Kindly compare this two. Now, I am telling you, Lordship, so far as pre-amendment is concerned, Lordship will find there is except D. That means
The other clauses are same.
except D, and in the next page, F is entirely same. Lordship has got?
Yes. No, F is there in the subsequent one.
No, in the subsequent one, there is a F. D and F are little different. Apart from that,
Oh, yes, yes. For determination of surplus
yes,
teachers, that clause is
yes.
there.
Yes, Lordship
Now-
will find. Now, Lordship will find. Kindly come to D of this. Unamended D and amended D. Let's understand if these two are going together. At best, they can pitch their case. Then what will be the anomaly? Let's understand
No,
the
no,
anomaly.
Forget about the prayers of the petition. Let me understand what is the
Yes, Lordship.
SOP that is prevalent.
Right. Now, that is one part, Lordship, which we have not
No,
been
no.
able to.
Because why I am indicating the letter of the DPSC chairman of 30th July, if you have a copy of that, 30th July 2026.
Yes, Lordship, I have.
In the last paragraph, it says that all sub-inspector of schools are requested to send the received transfer applications from zero enrollment, temporary posted, willing surplus as per first SOP,
Go to 163.
right? Within
Yes.
today,
Yes.
that is 30th July.
Yes.
And send the remaining received transfer applications as per revised SOP. So, for some of the transfer primary teachers, you apply first, for the next, you apply the second.
All the sub-inspector, Lordship, if all the sub-inspector are requested to send the received transfer application from zero enroll. That's Lordship. All sub-inspector of school are requested to send the received transfer application. Received transfer application from the zero enrollment. Zero enroll, temporary posted and willing surplus teacher as per first SOP within today, and send the remaining. So moment it comes to received of the transfer application, received, Lordship, kindly see.
Then you come to the first SOP.
Yes.
There was no option for giving willingness. Clause D, 7D. See, the language is for consideration of surplus teacher. Senior teachers in respect of date of joining in the present school shall be considered first for. It is pertinent to mention that there is
Lordship, can you see? If someone has applied for a transfer on 1st of July 2026, what is the fate? Lordship, let's proceed like this. 1st of July 2026.
Okay.
So the e-school are requested to send the received transfer application. Let us not think that this transfer application is pursuant to this. Suppose on 1st July, someone has received a transfer application. Received transfer application from zero enroll. Someone is frustrated, I cannot impart education, I want to be transferred. So this is one. Temporary posted. 2. And 3 is willing surplus teacher. Willing surplus teacher as per SOP 1. So this SOP 1 to be relate only to the willing and surplus. So to determine surplus, SOP 1 has been used, and willing is his willingness, because SOP 1 does not contain giving option. So what we are saying is, if I give a meaningful reading of this letter, then one is received application is to be treated prior that. Second is temporary posted and wheeling surplus teacher as per SOP. So surplus, we have to read surplus teacher as per SOP 1 and within today, and send the remaining application as per the revised SOP along with the given Excel sheet with forwarding and recommendation of every next working day of each time line this. So Lordship, kindly see first and revive SOP, transferred application format, and final vacancy list. Lordship is getting three things.
Yet not clear.
Yes, Malad.
Mr. Chatterjee has placed a SOP.
Only the second one.
Says that may be replaced by the following.
Lordship, that is then in that case, I would beseech your Lordship to take a
It's not
affidavit,
clarified.
not a entire affidavit of the matter. At least then Lordship, then the state should clear the stand, which is the SOP,
You
from
clear
which
that?
date to which date it has been followed. That much affidavit should be on record before we proceed. Otherwise, it happening as if we are trying to narrate to your Lordship. Lordship is
Then you file that till such period you don't apply that SOP or any coercive steps be taken with regard to the SOP and come up within a period of 10 days and a short affidavit be filed.
Lordship.
Because this anomaly is going through my mind. Yesterday also I said, if you apply, then there comes the discrimination. At the first instance, there is a clause which has been deleted. Now a new clause has been adopted. So there is a change. You have accepted the applications of some of them.
No, Lordship, if you no, even if it goes together, what I have tried to show to your Lordship is, even if these two goes together, there cannot be a discrimination. Why? Now, Lordship, kindly turn to the unamended element.
Okay.
Only portion this D. This D is determination of surplus teacher of a school. Teacher younger in biological age shall be considered first. However, any willing senior teacher may opt for being considered as surplus teacher. Lordship has got it. Unamended. And the amended, pre-amended was for considering supply of the senior teacher in respect of the date of joining in respect of the school shall be considered first for it pertinent to the mention that there is no such provision in the existing rule. Now pause here for a moment. Now Lordship, kindly see. Lordship, kindly see what we are taking here. This letter says transfer application from zero enrolled. That has got nothing to do. Second is temporary posted. And third is the wheeling surplus teacher. So basically what we have done is wheeling surplus teacher, otherwise younger in age. Let's read these two harmoniously. If you apply the first unamended portion, then wheeling.
You cannot interpret like
No, not it's not interpret, it's a written. Lordship, it is written that the wheeling surplus teacher. So if it is
to file your affidavit. You file your affidavit. We have heard at length of this matter. I don't think this will take some more time. Come up and take necessary instruction and come up which of the SOP is applied. And who is the
Let them
authority of
take all
issuing.
the points we are taking, all the points.
In such period, don't act.
Even your lordship, they can come up within 2-3 days. I'm not. Do this.
Mr. Chaturvedi,
Urgent basis.
a confusion arisen after the SOP has been placed.
Right.
Yesterday also I was in confusion that which of the SOP is being applied. What you say is correct that there has to be a drive taken because some of the teachers in zero enrollment, they are not discharging their functions. There has to be a rationalization.
Yes.
That I concede. But the SOP which is to be applied is to be applied without-
Uniformly.
Uniformly, correct. So we find that some of the applications were submitted on 31st July, in which it says that first SOP will apply. In the second one, the revised one, it applies to the persons who have not filed their application or given their willingness or option prior to 30th July. So they are considered in the revised one, which is the last date is the 6th August.
Lord, my instructions are,
What I suggest is,
My lord.
I am passing an order that please don't act on the SOP. Within a short time, you give that. I have heard the matter. It will not take much time for argument. You place your affidavits. Which of the SOP is being applied?
My lord, my instructions are, on instructions I say, that the revised SOP, my lord, is being followed. My lord, my lord, submitted it yesterday.
Just a find out. He says that both are being followed.
No, that I have not.
Mr. Chatterjee has submitted yesterday.
No.
This is,
My lord, the
I
have received
need your
instruction.
assistance because I cannot deal with this matter
My lord, I
until and unless this is clear that which of the SOP is being followed. There's a challenge to the SOP which is to be.
my lord, the revised SOP is being followed. My lord, may kindly, my lord, take it on record that the revised SOP is being followed. There is no dichotomy in so far as, my lord, the SOP being followed.
Then in what he is arguing in page number 163, I find that the applications have been submitted and as per first SOP that has been submitted.
Yes, my lord, but then
There lies the problem. You take instruction as to which of the SOP you will apply in case of the applications.
my lord, the revised SOP, my lord, at the risk of repetition, my lord, I say that the revised SOP, my lord, is being followed and will be followed.
We'll take it up in next Monday. Coming Monday. Whatever affidavit, short affidavit, you file it. I have heard it. We'll decide on all the decisions you have. In the meantime, please don't. You make your reply on that day. Let them file the affidavit just to.
Instead of Monday, Tuesday, my lord, only Tuesday.
Tuesday.
So
what will happen to that matter?
Which one?
That matter which is.
You lost my assistance. I will do it, my lord. I will do. But Monday, I have some difficulty.
Only one thing, my lord. We shall not continue with, my lord, seeking the options. Will not act upon it is what my lord's desire is.
No. Please don't act on this till Tuesday. We'll conclude the hearing.
Kindly permit us to collect the options, because my instructions are that we are applying the revised SOP. So in terms of the revised SOP, permit us to, my lord, take the options. We shall not, my lord, cause the deployment in terms of the options that we receive until my lord permits us.
My lord, I tell you, I have got your point.
You may have got the point, but I have not been able to convey myself to my lord.
Okay.
You
want to say that the process be continued, the action
will not be given.
Consequent actions will not be taken. That is what
because by that, my lord, no adverse consequence will not befall anyone.
Upon me, because I am questioning the surplus.
No.
How this surplus is determined?
That will be decided.
That's the point.
Surplus itself is in question. It will hit them only when it is acted upon, if at all it does.
1 minute from Mr. Chaturvedi. Apropos what has been indicated by Lordship, can take item number 5 for one.
No, we are not hearing. We are only on this issue. Only on this issue.
All that I'm
only of this week.
Yes,
please don't accept the options. Keep it on Tuesday. We'll conclude the hearing.
My lord, again, my lord.
Short. Yes.
My lord, kindly excuse me, my lord, for the repetitions that I make. But my lord, this has a purpose. My lord, with great hardship, my lord, this is being, my lord, continued. I again say, if
you
any
do one thing, you extend the time period from 6th August to the next date of hearing.
Yes.
Do that.
Because there is a closure date of 6th August. You extend by way of an corrigendum issuing till Tuesday. So that the persons who intend to opt can also opt. In the meantime, you come up with that affidavit. Hearing has already been concluded. We'll pass that order. Only to that.
Very good.
But you're
required to file any opposition to that. You have heard.
Yes,
you have made your submission.
I'm extremely grateful.
Extremely. And
but
only one thing can be taken on record that second SOP is being.
Only one thing, then this thing, if they do not on other points, how the surplus is determined, that points should come from affidavit. Then again further affidavit will be needed. Because we are harping on that declaration and identification of surplus is wrong.
My lord,
that's your loss, you may go against me.
The declaration.
I do not know how this is determined with reference to school or classes of this school.
Let Mr. Sanal not rob me of my prerogative of using my words and my
Tell
stand
me,
in the affidavit.
tell me within shortest period you can come up with the affidavit.
Lordship,
Whatever point
I
you
have a
intend to,
suggestion,
The
subject-
accurate, एक minute, हाँ. Blood,
including the aspect which has been indicated by me.
yes, yes.
Huh?
Blood, which of the SOPs is being blood followed?
That, and if any opposition to what he says, that surplus teacher, what is the principles being applied, it is dehorse the rules. If you intend to put in any affidavit, which is the shortest period you can do that, on that day I will conclude that, because I have heard it at length.
Blood, Monday, my lord, we shall file.
By Monday?
Monday.
No, Lordship, yes, Lordship, my senior said, Lordship, I have if your Lordship kindly consider. Collecting data is in process. Must have been completed up to 90% of it because tomorrow is 6th. But my learned senior said, kindly do not stay till 6th. Till the exercise up to. So we should, because Lordship said nothing should be proceeded with. I said up to 6th this collection should be allowed. And then on Monday we are coming back with this.
You keep collecting, only extend the date till 11.
You should be given an opportunity to
बोल
file our
सकते हो.
reply.
Till
Yeah,
11.
let them do it. We'll do it. Immediately we'll do it.
My lord is, my lord, as it fell from my lord, to extend the date, we shall extend the date and keep collecting the options.
If anybody comes to give their option, what is the difficulty?
My lord, I do not-
Petitioners are not coming. Petitioners are not
My
going
lord,
to give their willingness.
options according to so-called SOP is questionable.
Those persons who are not before this court, why should they be stopped from filing their option? Your right is not being hampered.
No.
They have given a SOP which is under challenge. So why should others be stopped with wants to give their
No, my lord, I'm not.
I am asking them to issue a corrigendum so that in the event these petitioners also want to flow with the others and give their option, they can also exercise that.
Non-exercise of option should not visit the petitioner with the consequence that they would be mandatorily subject.
No, I am not asking the petitioners to file any option.
Yes.
I am asking them to extend the date
Yes.
if the petitioners intend to exercise their option so that they can file their option.
But
If the petitioners want to take the risk of there being no interim order and thereby.
On the last day, leave was taken because of 6th August. As because 6th August is the closer. So I am granting them time. You go with the process. In the meantime, we'll hear out the matter, issue a corrigendum that date is extended till the next date. You file your affidavit, we dispose of it.
Lord, kindly, my lord, spell out the next date, my lord, in my lord's order, so
Okay.
that, my lord, it gets communicated.
But one fundamental issue remains about the irrationality deviating from the principle of last come, first go. That has to be ensured.
No, Mr. Bhattacharya, what-
Biological age can, my lord.
Yes. What I am into is 6th August is the last date. Now, some of the persons may be giving their willingness who is not before this court.
Right, so
So they should not be stopped.
that's
The
true.
process should go. As for the petitioners, if in the meantime they also decide to join in, they should not suffer for filing the writ petition. I am not
Right.
stopping them. Let the state issue a corrigendum extending the date to a certain extent. We will hear out the matter, call for the affidavits also, because I have sought for the instruction at who has issued and the anomaly with regard to the first SOP and the revised one.
Very well.
But so far the transfer order they will not issue.
Issue.
That he is saying that how can that be? Without
The date
taking
is
the options,
extended.
how can that be?
I did not expect this coming from
If
Mr.
date
Sanchal. is
extended, suppose I give a date, that date is extended, they issue a corrigendum. Until the process is completed, how can they issue?
But if your lordship not hears out the matter before that, there is no problem.
No. Ashun.
Well, transfer orders are being issued. Transfer order is being issued.
পুরোটা কমপ্লিট করার আগেই করে দিচ্ছি
They are being issued. They're not taking the full facts if your losses. Transfer order are being issued.
The process of collection of data is still going on and the transfer orders are also being
This is
issued.
not a representative capacity suit.
Yes.
This is not a representative capacity suit. Whether the petitioners are being served with transfer order.
Oh, that's not the point.
No, that's is the point. This
No,
is not
SOP is
representative
giving
capacity.
effect to. SOP is giving, I were questioning
That's all
stay of
right, but this
clarify
is not
that
in a
it is
representative capacity.
data be collected, but on the basis of that collection of data, no transfer order.
Should be.
Yes, that is the only thing.
Let them
Collect
That-
it, but then extending the date.
Let
Yes,
them
so that will maintain the balance. I'm deeply obliged.
করছে issue করছে
Oh, on a regular basis
Collection
there.
is by force হচ্ছে।
Yes, yes.
চলো।
30th July
The
there.
word willing is used. I don't know why Mr. Sanyal is saying force. Willing.
But then, as per the existing law, they can issue transfer order. Why you are apprehending that on the basis of?
That's different. That's not on
Not
issue.
as per SOP.
Okay.
But the observation given by the
Don't
lordship
say that
that
it is under SOP.
right.
Yes,
That
it
let
says
let that
so.
order be passed.
Policy 10th July. It says so in so many words.
The
Statement from the bar.
No, not from the bar. Not from the bar.
Mr.
This is a
Mojumdar,
submission
please,
affidavit we are filing. This is not from the bar. 10th July.
Point issue.
So let it come on the record, we will take.
We'll do that. When reply, we'll get it.
by the similar issues have been raised in the aforesaid writ petitions, and accordingly, the writ petitions are. We can take it analogously. All the writ petitions.
Yes.
Analogous.
Will be
To the SOP. Challenge has been made by the petitioners with regard to the
24 Parganas.
procedure.
They are referring to this 10 July.
In short, SOP adopted by the state machinery for identifying the zero enrolled schools, surplus, the schools having surplus teachers,
Screen টানবি তো?
and for rationalization of deployment of teaching and non-teaching staff through the transfer of personnel. Heard the learned advocates representing the petitioners as well as for the state. During the course of hearing, it is found that two SOPs are being issued later dated 30th July 2026 of the chairman DPSC.
তাকাতে হবে। ঠিক আছে, এখন দিয়ে দিবি।
For clarification as to which of the SOPs are being adopted, learned advocates for the state are requested to apprise this court by way of an affidavit. No, Chairman, 30th July. It item number 4, 19893 of 2026. From the letter of the chairman DPSC, it appears that the junior teachers of surplus schools, the last date is 6th August 2026. Accordingly, state is directed to extend the date of submission of option till একটা ডেট বলুন নেক্সট উইক এর জন্য শুনে নেব টুইসডে ওয়েডনেসডে যে কোনো দিন by Tuesday you can come up with that
yes.
the Tuesday মধ্যে যদি ফাইল করে তাহলে একদিন রিপ্লাই Wednesday Thursday তে I'm fixing the matter on next Thursday.
I'm grateful to you.
Can it be?
And by Tuesday, you file your opposition, whatever, reply by Thursday.
Can it be Friday, my lord?
Friday, miscellaneous matters are there.
Thursday, my lord. Even
Wednesday call.
No, on Thursday, don't extend.
Wednesday.
No, we want Mr. Majumdar here.
On Wednesday?
This is for personal reasons.
On Wednesday?
Wednesday.
By Wednesday, you file your reply?
Wednesday.
Wednesday?
তোমার তো ফাইল করছি সোমবার তো বুধবার রাখো
12th হচ্ছে ওটা
ওভারনাইট দিয়ে দেবো
till 12th না ওটা কবে হচ্ছে দেখো থার্সডেটা কবে হচ্ছে হ্যাঁ till 13th you issue corrigendum till 13th on Wednesday we conclude that hearing whatever reply they will
I'm grateful to my lord, deeply obliged.
till the respondent authorities concerned is directed to not to give effect to the SOP till the next date of hearing, that is till 13th করবে।
If we do not give effect, then we can't collect
We
options.
clarify that. It is clarified that the process of collection of data as per SOP will be processed. Full stop. It will be processed,
I'm grateful, deeply obliged.
but not to give the effect because they are also raising this plea. In the meantime, you come up with the affidavit. It has been heard. We'll dispose of
Or
it.
affidavit only on that point, not no other point.
No, other points are also
The
there.
losses kindly
Why?
indicate that, otherwise they will come up only say.
We'll keep it short, my lord.
My lord,
On that.
in
In
respect of
all respect of all points.
my lord, in respect of the my lord, item number 1 and 5, my lord, kindly see the my lord SOP was issued in respect of primary. I am representing the my lord, DPSC Nodia as well as secondary. My lord, kindly clarified it. This order would be governed in respect of the primary teachers.
It is clarified that the order will be restricted to primary schools only.
না affidavit তো সব পয়েন্ট চাইলো
হ্যাঁ?
চেয়েছেন
ওই তো by
কিন্তু
Tuesday and reply by Wednesday.
সে করে দেবো
আর Wednesday তে আসবে। 13th আসবে না? Wednesday? 12th এ আছে।
হ্যাঁ আর
13th অব্দি এ করবে। হ্যাঁ
My lord, let those be served on us, my lord. Just, my lord, they are handing up, my lord, we.
After the hearing, why you are coming up with supplementary?
But that transfer order, they are issuing on the basis of paying today. I believe, my lord, they will give us an advance copy of the affidavit by Monday morning, so that.
Advance copy will serve.
My lord, we give it by Tuesday.
আরে টিউসডে রাত 9টার সময় দিলে তো করতে পারবো না একটা
Tuesday by the
একটা তো
stroke of the
সময় দিতে
midnight
হবে।
hour. থেকে বুধবার হলো। এখন তোমরা আবার বলছো আমরা মঙ্গলবার থেকে সোমবার।
আর তোমরা সময় চাও না তো কপি দেওয়ার পরও সময় নাও না তো
Mr. Sandal, please don't.
don't be something be reasonable.
My lord, we have to go through, my lord, we have to find reply if required.
No. What
Have
you
to
do
give
is
a time to deal with it.
during the course hours on Tuesday, you give that so that on Wednesday they can file their reply and on that day
During
we
the court hours you give me, we will deal with it.
supplementary affidavit
আর
copy.
করতে লাগবে তো আমাদের কাজ।
Supplementary affidavit filed in WPA, leave it there on the prior learner advocate, leave is granted 19417 of 2026.
বলে যাও কি করবো তো তাই হবে না मतलब your lawsuits will be taken up criminal matters in the second half in all probability.
Assigned matters are there, criminal matters are there.
There are some matters, top matters, item 40 to 45. 44, I'm sorry. So if your lordship takes up those matters at 2 PM, subject to your lordship convenience.
Or tomorrow morning your lawsuit.
Which one?
There is a 12 noon fixed matter.
The leave matter starting from 40, 41, 42 and 43. No. I have something. My lord, deliberately, they have not made the commission as a party. All along, the matter went up to Supreme Court where commission has fought out there. Now, my lord, I would be seeking that they should add me as a party.
We do that during hearing.
So this is in respect of a letter has been issued by the Director of Madrasa Education.
Following Najma matter. Now, in the Najma matter, the commission intervened before the Honorable Supreme Court. But I have no difficulty. I have got the soft copy. Lordship may pass an order so that the commission is made as a party so that I can make appropriate submissions. Because, my lord, no, it is not. It is not as simple as that. Otherwise, I would,
41.
from 44 matters, my lord. 40, 41, 42, and 43.
44.
44.
40 who is appearing?
Well, all are identical matters.
41, my lord, I am appearing.
41.
42.
42 probably I am for the
Well, 40 to 44.
40 to 44.
Yes, Lord.
In none of the writ petitions you are party.
No, and that's a very deliberate, my lord. When the situation comes, I'll say why.
Who is
No,
for the
choice is ours probably, my lord.
That
If
choice-
my learned friend feels it
Well,
under the
lordship
civil
will
procedure
tell
code,
us
he can
if your lordship
apply
finds
for
that
it.
it is a necessary party, then obviously.
No, that's I can make submission on that, but I don't think they should delay on that part. Kindly let pass an order adding the commission as a party, and I don't seek adjournment of it. I don't say that for that purpose adjourn it because I'm ready with the matter. I say there is a deliberate reason. Because in fact, following the Najma judgment, my lord, I made submissions in another matter. Lordship has also made lot of reasonings. Now that is on the merit of the matter. Lordship may kindly pass an order. Otherwise, what will happen, my lord? Lordship has power. Lordship can always add any person as a party if Lordship feels so. Otherwise, I have to unnecessarily make my lord, applications in all the four matters. The matter would be
Yes,
delayed also.
40. Who is for the petition in 40? Taking party? Commission?
But I was
Are
party
the-
in all the matters.
Certificate of service. Filed on behalf of the petition is taken on record. When?
Yes, I have no difficulty. I am ready with the matter.
ফিরে আসি কেন? দুটোর সময়টা রাখো না দেখে নেবো at 2 p.m.
Yes. Well, that 2 actually means I hope 2:30 because it's already. Lordship will have to have tiffin and me too.
2:30.
I don't know.
I'm sorry, Mlat. There is a 1:38 item. I don't know, 1:30 is a 12 p.m. fixed matter, Mlat. Mr. Thor is happy representing the commission, Mlat.
Maybe any another day.
Kindly fixes a time, so that we are waiting for item of 138. 138 to 142, Mlat. These are similar matters, Mlat. We have completed our submission, Mlat.
Well, this is a matter on the pursuing bit. I completed my submissions.
Since long this matter is pending, Mlat.
Lordship may fix it on
Any day as per Lordship's convenience, Mlat. Kindly fixes a time, Mlat.
What is it? Oh, one of the matters will go out. What is this matter?
Any day, Mlat, as per Lordship's.
What is the matter? Fact.
This is a matter where pursuing bids were allowed by the commission to participate in the selection process, who according to us are not eligible for the selection process. Training qualification is must to be eligible for the selection process. That is our case.
পার্টারটা না এটা যে ডেট ফিক্স কর এটা এর মধ্যে একটা বেরিয়ে যায় একটা বেরিয়ে যাবে 139টা দাও পারবে বার করতে
One 38 to 42. 138 to 142.
ABM Abdullah.
Oh, that's it.
We have also submitted our written notes also, Mlat.
Written notes have been submitted.
Yes. But the added respondent is yet to
Well,
complete my submission.
I have completed my submissions and I have also given a very short note. That is already, my lord, handed over.
The last occasion, Mr. Shobushai Chatterjee started his argument.
I had a talk with Mr. Chatterjee, Mlat. He will take not more than half an hour.
Yes, yes.
50 minutes to 30
Who is
minutes.
appearing in item number 139?
139.
It's a matter of sir.
139, who is appearing?
Is it Mr.
Mr.
Can
Firdous
four-
Kami 139, I think.
Can 4 of 2025 and can 5 of 2025? This is can 4. What is can 4?
Addition of 41.
Addition of what?
Well, in
Lord, I am led by
139,
Ms. Vishwas.
139, the advocate record is Gopa Vishwas.
Yes, ma'am.
Is 139 I am releasing on my personal ground.
My lord,
Precisely, that's the
lord,
reason I have
lord.
indicated.
my humble request, my lord, she is not over here at this point of time. Kindly, my lord, pass this
I am
order.
releasing the matter on my personal ground.
I am led by Ms. Vishwas.
D tag. The WPA.
My lord, I am led by Ms. Vishwas and she is not present. over here.
WPA 139 ta kota hoy? 13463 of 2023 along with the connected applications are de-tagged and released from the list of this bench on my personal ground. Mr. Shamim Ahmed, learned advocate for petitioners, learned advocates representing the petitioners in the other writ petitions, as well as Mr. Dhar, learned senior advocate appearing for the commission seeks for fixing a date for final hearing. Follow?
ये भूल बोलो ना उठ के दादा दादा up to 140 to
বলো এটা পাঠাড আছে হ্যাঁ? Twentieth August you find out?
28.
20.
20.
Act.
Item number
At
140 should
কবে
also.
কটায় হচ্ছে 2 p.m.
Item number 140 should be.
140
Yes, my lord. Mr. Shudipta Dashgupta is appearing for the matter.
And all
140
are
is
accepting 139, all remain.
I'm grateful, my lord.
20.
Chal. Thank you. Chali.
we are troubling your losses a lot.
Solve your trouble. This is also nothing is trouble until and unless resolve the thing.
We take it 230 because it's already 147.
230 then. Okay.
এখন নামটা দিন এখন নামটা দিন My lord, only thing is that if
Yes.
I shall satisfy your lordship, my lord, why he has not been arrayed as a party. He is neither a necessary
no,
party,
if
not even a proper party.
no, if my learned friend insists that I should make submission before your lordship that why I am a necessary party, then I have to make submissions.
My lord, he
May I just
he
complete?
cannot,
May-
my
may-
lord,
No,
he
no.
cannot, my lord, be a spanner on the writ petitioner's wheel. If he has anything to say, let him file an appropriate application, my lord, seeking impediment. And my lord, in that event, my lord, your lordship may, if your lordship so desires, my lord, may add him as a party. For the present, my lord, we are questioning page 166 in
My
the
lord,
writ
in
petition.
that case, my lord, in that case, in fact, I had the judgments. There are two circumstances. One is there are situations where the court, based on a prayer, after seeing couple of points, can very well straightway pass an order. Other option is one can also make an application. So I initially thought maybe my learned friends would not insist, since I don't want any adjournment. I don't say that because of my interventions they should get affected. But now since they're insisting on that, my lord, may I just show that why lordships can and should straightway
Provided
first.
your lordship is first satisfied that their presence is necessary
Yes, exactly.
in
I'm
the matter.
saying,
Make the
I'm
submissions,
saying
how will
that.
they consider?
I'm saying that. I'm
My lord,
saying that.
he is the commission. Kindly see page 166.
I know what.
166 does not even contemplate him.
Well, it does. It begins with following a judgment. 166 does not stand on its own footing. 166 in compliance with the Naj. No. I am, because I was before the Honorable Supreme
He
Court.
was not. With greatest of respect, he was not.
Please take
My lord, with greatest of respect, he was not.
My lord,
The Madrasa board was there.
no, please.
My lord,
An
Madrasa board
instruction
was
now.
there.
Don't
I
let
am
us-
saying, my lord, I appeared
I
before
have
the
the order. Let us,
I also have the, I appeared before the Supreme Court. He did not.
let us, Mr. Bhattacharya, this is the order. We had to intervene. I will not make a factual incorrect submission.
My lord, he was
Kindly
not
have a
before
look
the
at this.
Honorable Supreme Court on the final occasion.
I was. You deliberately did not, and I had to went before the Honorable Supreme Court, and the Honorable Supreme Court was kind enough. Kindly have a look at that. So that's, let us, well, factually, why we should be different.
My lord, factually, I am telling your lordship, my lord, this order that has been
No, you
referred
cannot
to,
say that, Mr.
that-
Bhattacharya.
my lord,
Factually, you
my
are
lord, the
wrong.
Order that has been referred to by the Honorable, I mean, authority. In that order,
That's a different thing.
Mr.
Let us not
Huzefa
change topic.
Ahmedi was
Let us not change
representing
topic.
the
You said
Madrasa
that
Board.
I was
The
not before
Madrasa
Supreme Court.
Commission was not even heard there.
But-
Even if it was there, it was not even heard.
This is-
I am indicating it to your lordship. I was there also out in the matter.
We add the Madrasa Services Commission as a necessary party.
Please, I'm not.
My lord, he cannot. My lord, kindly.
No, we'll add that. If he, after intervention allowed by the Honorable Supreme
And
Court,
kindly have a look at.
is made, that is separate issue, but he is a necessary
And
party.
kindly have a look at, my lord. Kindly see paragraph 41.1. This is the consistent view. I never wanted to stand in the way.
My lord, he is. My lord, before even me opening my mouth, my lord, he is making submissions.
No, because.
My lord, he has got no role to play here. at the
Kindly have a
present
look at
moment.
paragraph 41.1.
My lord, these issues.
No, may I? Let us go one by one. Kindly see 41.1. The court can, at any stage of the proceedings, either on an applications made by the parties,
Further, a judgment is
or
not required, my lord.
may I, or otherwise direct implement. And here 41.3, and this is the judgment of the Honorable Supreme Court, and our High Court has also made consistently, even on the suo motu. And why I am an absolutely necessary party? Because of the color has been changed after the Najma. From 13 July, the entire, my lord, the concept has been changed by the Honorable Supreme Court. Kindly have a look at, my lord, the paragraph 8. There, the Code of Civil Procedure invests very wide and extensive discretionary power on any. Sorry.
Yes.
Yes. Judgment. First one was. May I just give the citation?
Para 8.
Yes, my learned friends are asking for the citations. First one was 2012, 8 SCC 384, paragraph 41.1. And this one This is 2025 SCC Online, Calcutta 752, paragraph 8. That's suo motu. The Code of Civil Procedure invests every wide and extensive discretionary power on any court in the matter of joinder of parties. Such powers can be exercised by adding, deleting, substituting, or transporting parties to a suit with a view to adjudicating the true and real controversy before court and by avoiding multiplicity of the proceedings. The powers can be exercised at any stage, either on an application by a party or suo motu. But I'm on that. Lordships can. My lord, the other judgment is kindly take, this is 1992 2 SCC 524. Even if I am not necessary, though in this case I am a necessary, a person who is a proper, he also needs to be added. Well, this is 92 2 SCC 524, paragraph 14.
Yes.
Well, this is a very consistent view that after leaving my lord 4-5 lines, it is not he has. It is not merely that he has an interest in the correct solution of some question involved and has thought of relevant arguments to advance. The only reason which makes it necessary to make a person a party to an action is so that he should be bound by the result of the action and the question to be settled. Now, my lord, these are the judgments. Why I say I am absolutely necessary party, because of the reason they are challenging page 166. Kindly take my lord 166, where I come.
Yes.
Well, 166 begins with, in compliance with the verdict dated 13th of July. I'm not touching anything else. So this is not an independent otherwise action. It's the same proceedings. So now why I say, now kindly have a look at this. Why, what is my role? Najma. On 13th of July, in fact, in another matter, which is yet to be uploaded in the server, Lordship has been kind enough to deal with certain aspects of the matter. That
Go.
Yes. Now, the point is, before this, may I just say, my lord, thereafter I would show why I say. Lordship need not look at it. There are 3 judgments. One is the Rafiq. Some paragraph they are relying on. That based on a paragraph 64 of the. This is an addition of party.
Your lordship has been pleased to add.
No. I'm on.
Is he making submissions on merits? Kindly.
Mr. Bhattacharya,
Kindly, he is making submissions on
I
merits
have
now.
to, because it is for addition of party. I'm asking.
Your lordship has added him.
No, I have not completed.
Your lordship has added him. Your lordship said that he has been added.
Oh,
If he's so eager,
if it is added, then I don't say anything. Yes, then I'm sitting. Correct. But I was under the impressions you were objecting. That's why at the beginning.
It fell from minor that your lordship has added. Your lordship indicated that they are being added.
Very good. Lordship may kindly pass one line order that I am added. That's all. Let them start. I don't stand. Because you are rejecting, I had to say.
No, my rejection did not weigh with my lord. My lord said that your lordship is
well, fine, I understand. Now that's good. Why should I waste time?
The later, you're challenging the later 166.
Yes.
The later under challenge.
Your lordship is passing the
The later under challenge, dated 25 July 2026, has been issued noting compliance with verdict dated 13 July 2026, passed by Honorable Supreme Court of India in WPC number 566 of 2024. Mr. Pratik Dhar, learned senior advocate appearing for the West Bengal Madrasa Service Commission, indicates that in the said writ petition, applications were filed by the West Bengal Madrasa Service Commission, intervening applications, which were allowed by the Honorable Supreme Court. And as such, the Commission is a necessary party in the present writ petition. He seeks for addition of the commission in the array of respondents. To buttress his contention, he relies on following decisions. Eta kore deben decisions please. Ei duto decision. একটা হচ্ছে 2012 volume 8 SCC 384 আর একটা 1992 2 SCC 524 and 2025 SCC online Calcutta 752 আপনার it is found Mr. Bhattacharya, learned advocate. You object to this? Leaves the matter to the discretion of the court. It is found that in Najma Khatun Supra, the commission was allowed to intervene and was made a necessary party. In view of the above,
One correction, I
Yes.
stand corrected. I just want to know, or I just want to whether the commission was added as a party in Supreme Court or was an intervener in Supreme Court.
Well, their implement application was allowed. I have given that order.
May I just indicate only one thing? May I just indicate only one thing? Only one thing. My lord, I was also out in the Supreme Court in this particular matter. My lord, at no stage did the commission, apart from intervening, my lord, file any affidavit or disclose any stand. My lord, it was, my lord, Mr. Huzefa Ahmedi was representing the Madrasa board, and my lord, Mr. Parasaran was representing the state. There was no one else, my lord. Even if he was there as a whatever party, my lord, he never made, no one made any submission on behalf of the commission. The entire judgment does not even reflect anything regarding the submissions of the commission.
My lord,
What should we kindly also record this? There is a direction by the Honorable Supreme Court after, my lord, the judgment on the commission.
my lord, I specifically said after 13th of July, because of the effect of the Supreme Court judgment, my role is completely
Najma,
different.
the intervening application was allowed by the Honorable Supreme Court. Whose application is this? IA 203600 of 2024.
My lord,
This is for implement.
yes, that seems to be commission's application.
So the
But
implement
I can seek instruction on that. In any case, lordship has seen that next paragraph.
And as interveners, they were allowed. As interveners, they were not. The intervener is one thing.
Would be limited. Questions of law.
if a person or a commission is allowed, why you are put in a difficult situation? I don't understand. In Najma,
That-
commission was there.
Let us be ad item on this, my lord. Let him be there.
Let the West Bengal Madrasa Commission be added as added respondent number, be added as impleted as added respondent number 11. Leave is granted to learned advocate on record for the petitioner to make necessary amendments in the cause title of the writ petition. Learned advocate on record for the next term is directed to serve copy of the writ petition and its actions.
They have the copy.
Well, I have a soft copy I have taken from the Sharthok. I'm not seeking any adjournment on that ground, but officially they should give, because not
Amended copy, my lord.
not everyone
Mr. Singh is
uses.
going to do it, my lord, in course of tomorrow
Yes.
or today.
Let your matter continue,
You have been served.
but officially you should give a hard copy for the office.
এটা হলো 40 থেকে 44.
My lord,
40 who is appearing?
I'm-
And 41 to 44.
Well, all are identical. 40 to 44 identical.
44 are identical, and I am 44. Not even 41, 42.
42, 41 and 43.
41 and 42. So, Authority Banerjee is there, now we need more.
See, on
My
the
issue is same.
applications,
Yes.
your
Yes.
prayer is allowed impleted. 41 এর শুধু রেসপন্ড নাম্বারটা দেখে নেবেন।
Well, deeply obliged.
Yes.
my lord, what is the issue before your lordship?
Milord, the West Bengal Madrasa Service Commission Act, the constitutional Milord, provisions, Milord, it was declared to be ultra vires by this honorable court by a judgment and order delivered by your lordship's court in 2014.
Yes,
Milord, am I
just a minute. Hey,
tomorrow, please see page 166. Tomorrow is the day. That was the urgency. We have been served, my lord, only on the 1st.
কটার সময়? না আমি 12টা 12:30 নেব।
I have no quarrel, my lord.
Let the matter be fixed tomorrow 12:30.
Tomorrow there is some difficulty. I am indicating it to your lordship. Tomorrow, the hearing is fixed.
Achha, tomorrow 12:30 I'll take it up.
Let us pray for an adjournment tomorrow before the authority, your lordship keeps it, on Wednesday. Because already in the other matters, the hearing was fixed on 3rd. And they have prayed for adjournment. The matter has been, no date has been fixed. Your lordship, next Wednesday, my lord, we'll pray for an adjournment before the authorities.
Let that not be, my lord, recorded in my lord's order.
No, I am not granting any liberty to them to seek for adjournment. Only on Wednesday it is fixed.
Yes. No adjournment.
He says that he will be seeking adjournment.
He will face the, because it is in, yes, in compliance of the Supreme Court judgment, they have been asked.
Today, your lordship,
give their documents.
No time.
Kindly for 5 minutes, kindly.
Then come tomorrow at 12:30.
At 12:30, I am in some personal difficulty. That is the
Well,
we can come at 11:30 if it comments to your lordship. 11:30.
কালকে দেখো তো 11:30 সময়।
Kindly 11:30.
Yes.
কালকে?
Tomorrow 11:30.
Ask.
Yes,
11:30.
Kindly pardons me, I am in some other commitments are there. The other matters are.
Then you can come on Wednesday.
No. Kindly visualize, what has been done. Kindly, what has
then 11:30 tomorrow.
Some choices you have to opt from one choice.
I would need to learn that from
either you choose Wednesday
what choices are,
or you come on 11:30 tomorrow.
Yes, 11:30.
11:30 tomorrow.
Yes.
Affidavit of service.
Affidavit of service will be there. Order has been passed. Tomorrow it will appear. কালকে করো. Please this matter tomorrow at 11:30.
Well, the hard copy of the petitions, they should serve to the office of the commission also.
Mr. Bhattacharya, serve the hard copy of this petition to the office.
Or give it to the AOR, whatever. That's the most convenient. Give something so that
or
it is
you have
processed
received it from the Sarthak. I think within this
But I
you can go
use-
through and make your submissions at the preliminary stage.
But we can serve a copy and I can give the copy.
ওকে দিয়ে দাও না তাহলেই হবে।
এটা রাখো না। এটা কালকে 11:30 সময় অবশ্যই।
চুপ কর তো ভাই।
তুমি কলারটা খুলে বলছো একটু কলারটা নামিয়ে
দাও অ্যাসাইনমেন্ট দাও। কোনটা আছে এখন কটা কোনটা আছে বলো না।
My lord, my lord, may I make one submission? It seems, my lord, one assigned matter, my lord, that probably is fixed before your lordship, my lord, at 2, my lord is pleased to take up that. My lord,
No.
9. No, mine is, my lord, at 3 p.m., my lord, that's fixed. My lord, I also have, my lord, another matter fixed. My lord, if your lordship, if by any chance is taking up that matter after this one, my lord, my learned friend will be there, my lord, let them finish, my lord, on the next day I'll address your lordship. I'm grateful.
How was the? এখন তাকে এখন এটাকে রিলিজ করুন।
I thought that, my lord, we have missed the 2 o'clock train because 3 o'clock train had already come in. So I was a bit apprehensive about it.
Yes, এই কাগজ দাও। Yes.
No, sorry. Yeah, argument ko tai nahi na. May it please your lordship. My lord, dear lordship, I am pleased to hear this matter. My lord, just for recapitulation, my lord, the writ petitioners are aggrieved by reason of, my lord, total inaction on the part of Asansol Durgapur Development Authority for not, my lord, adhering to their commitments. The commitment had been made in writing and that had been placed before your lordship. The grievance of this, the cooperative societies is this, that these are cooperative societies consisting of so many people, mostly middle class families who had put in money for the purpose of having some habitation by way of, my lord, development of properties which had been undertaken by Asansol Durgapur Development Authority. Now, my lord, the government of West Bengal allotted these plots of land to Asansol Durgapur Development Authority for the purpose of development of the land for growing industry, for rehabilitation of people, etc. It was, my lord, by basically socio-economic program that the government wanted to have through the instrumentation of Asansol Durgapur, this Adda. Now, my lord, the basic, I thought, my lord, by looking into this program, that the basic intention of this organization was to ensure rehabilitation of people. For that purpose, my lord, there will be the construction of buildings in the plots allotted, and then, my lord, it will be given to the different cooperative societies for the purpose of rehabilitation of the people. This was the basic idea. My lord, with that object in view, as early as in September 2010, Asansol Durgapur Development Authority invited applications in prescribed forms for the purpose of allotting different portions of land. Well, 3 organizations, well, 3 phases were contemplated. One is for Urboshi phase 3, the other one is, well, at CMARI colony, and the third one is Kollanpur. Now, my lord, these 3, your lordship will be pleased to find, for the purpose of this, they issued, my lord, this brochure. And my lord, my submission will be basically on the basis of this brochure, because my submission will be this, that by issuing this brochure and inviting people to act on the basis of this, this particular Asansol Durgapur Development Authority, this development authority made a representation that if you do this, then we shall be allotting you land for the purpose of construction of building. This is a clear case of a representation made unequivocally, unambiguously as to what they intend to do in future. My lord, kindly come to the writ petition, page 24.
এটা বার করো ফটোকপি করে যেটা করা আছে না
I will first, my lord, basically I shall argue on this particular brochure, and I shall show to your lordship, my lord, how the petitioner has acted on the basis of this. The writ petition, my lord, this is 12514 W of 2016.
হ্যাঁ দিয়ে দেবেন এটা তো ক্যান অ্যাপ্লিকেশন শুধু petition to it.
Writ petition, page 24. চেয়ার নিয়ে বসো, নয়তো মাটিতে বসে পড়ে এটা নিয়ে যাও।
Page 24.
Yes, my lord, page 24. This is the information brochure which had been, my lord, issued by this, your lordship sees at the bottom, Asansol Durgapur Development Authority. Their address has been given.
Just a minute.
But there have been too many papers, my lord, had come in here. I had a lot of problem in, my lord, sorting them out.
ওইটাতে দেখো তো রিটের কপিটা আছে জেরক্স
The writ petition won't be very thick.
এইটা হবে মনে হচ্ছে রিট পিটিশন page 20. Yes, introduction is the heading. Heading is the introduction of that page.
Yes, information brochure.
Page 24.
Page 22.
22, yes.
Lordship will please to see that plots for residential cooperative housing society, top, immediately after this information brochure, plots for residential cooperative housing society at Urboshi complex near CMRI colony, Durgapur, and KSTV's Kollanpur steel plant or something. And these three, my lord, were the cooperative, for these, my lord, cooperative housing societies were invited. Now, lordship will be pleased to come to page 24. See, my lord, they themselves are describing their own, the area of performance. The government has set up Asansol Durgapur Development Authority for planned and integrated development of this region. ADDA, or Asansol Durgapur Development Authority, was established under the West Bengal Town and Country Planning Act, etc., merging the Asansol Planning Organization, Asansol, and the Durgapur Development Authority, Durgapur. The Asansol Durgapur Development Authority has been spearheading the cause of industrial, infrastructural, and other development activities under its jurisdiction, which extends from Panagarh to Borakor, with a total area of 1,615.90 square kilometers, covering about 30 lakhs of both rural and urban population. So 30 lakhs of, my lord, this is a sort of, I should say, a carrot was being dangled in front of, my lord, 30 lakhs of rural and urban population. Acting as a change agent for infrastructural growth and technological advancement, Development Authority, I am not going to use this word term ADDA. This, my lord, sort of lightens the seriousness of the matter. So this Development Authority is entrusted for giving shape to a host of industrial estates, growth centers, and industrial and residential townships. Then Development Authority has given special emphasis on the development of quality infrastructure in its planning area with a view to provide better living environment. But nice, sounds very nice, my lord. And people were, my lord, allured by this language. Presently, it witnesses a boom in the educational, retail, hospitality, housing, entertainment, and knowledge industry sectors. Adda is one of the prime movers in changing the face of Bengal and is the best alternate to any crowded metro in this country. Well, these are very noble ideas which have been formulated in the form of this brochure. Then, my lord, I am not going to trouble your lordship with this. Kindly, my lord, turn over the page. And the various, my lord, their promises have been made as to what they are going to do. This setting up energy park and all that. Then, my lord, very rosy picture has been given in these 2 pages. Then kindly come to page 25, the last paragraph. This development authority offers to allot 94 numbers of developed group housing plots at Urboshi Complex City Center, CMR ERI Colony, and Kollanpur Satellite Township, KSTP, in the Asansol area. The residential areas are within Durgapur Municipal Corporation and Asansol Municipal Corporation, having communication access to the main business center. Then schedule of plots. This is very important. Schedule of plots, my lord. Your lordship sees 3 blocks have been given. The first one is Urboshi Phase 3. Then second one is near CMERI Colony. And third is Kollanpur Satellite Township. Now, kindly note, my lord, Urboshi Phase 3, Type A, area of land 12 katas or more. Number of members must be minimum 16 members of cooperative society. Number of plots 3 numbers. Rate per kata is rupees 3 lakhs. 10% of the land premium. Rate per kata is rupees 2,50,000. And my lord, 10% of the land premium will have to be given along with the application. And my lord, that land premium has been mentioned as 3 lakhs, 2 lakhs, and 1,50,000. Similar is with regard to CMRI and similar with regard to Kollanpur. Then my lord, kindly turn over the page. I am not troubling your lordship with categorized reservation of plots. Kindly, my lord, come to page 28. Who can apply? Any cooperative society consisting of 8, 2, and 16 members of Indian nationality can apply. There only one member of a family of etc. and dependent parents, son, unmarried daughters can be a member of the cooperative society. Eligibility criteria has been given. I'm not troubling your lordship. I'm not troubling your lordship with the page 29. Kindly come to page 30. This is also important. How to apply? Applicants should apply in the prescribed form enclosed, duly filled in, and signed as required therein. Then 1, the information brochure to be purchased in cash from the State Bank of India on payment of rupees 1,000. My lord, this will be, I am going to calculate before your lordship as to what is the amount of money, my lord, this development authority has taken from these people. And thereafter, my lord, they did not proceed with this, my lord, for the purpose of allotment. Kindly see, first is 1,000 rupees by way of to buy the information brochure. So if 15 persons buys information brochure, they will get 15,000 rupees on account of the price of information brochure. Then the application should be accompanied by non-refundable registration fee of rupees 2,000 along with 10% of the value of the land premium as application money. See table at page 3. I shall take your lordship to that. Therefore, second item of payment is 2,000 rupees by way of registration fee. So the number of registration into multiplied by 2,000. So it will depend upon the number of cooperative societies who are, my lord, getting this registration. Third thing is, my lord, along with this, my lord, one will have to pay 10% of the value of the land premium. Your lordship has been pleased to see at page 26 the value of the land premium. 10% of 3 lakhs, 10% of 2 lakh, 10% of 1 lakh 50. So 10% of 3 lakhs will be 30,000. So 30,000 rupees one will have to deposit along with the application. So this money is, my lord, go into the pocket of the development authority. Why am I putting in this money? Because the development authority has promised that, look, if you do this, then you will be allotted land. A lottery will be held and then your name will come up. So this is what it is. Then, my lord, item 3, paragraph 3 at page 30. Payment should be made in 2 separate bank drafts pay orders. One for non-refundable registration fee, another for 10% value of the land premium, issued in favor of a Sansol Durgapur Development Authority, payable at Durgapur, including bank charges, if any. Then, my lord, kindly turn over the page, page 31. The mode of payment. The last of these paragraphs. Mode of allotment, process of lottery, the first one, the process of lottery. Then date, time and venue of lottery, that has been given. Mode of payment, after issue of formal allotment letter, the society shall have to pay the balance premium as per the following schedule. 25% of the land premium will be paid on being successful in the lottery. 10% application money will be adjusted within 30 days from the date of issue of the allotment letter. Then balance land premium of the allotted land to be deposited on or before 90 days from the issue of allotment letter. Then 10% deduction of land premium is allowable in the following, then schedule caste, schedule project, etc. Then, my lord, kindly come to page 32. Terms of allotment, no interest will be paid on the application money. So, my lord, this money will go into their pocket. They will not pay interest on this and they will keep it. The promise was that in pursuance of this brochure, we shall allot the land in your favor so that you will be able to construct building and, or my lord, if the buildings are constructed, you will be getting the allotted land and the building. Now, my lord, the position is this, that this is in 2010. 2010, they got this amount of money. The amount of money, my lord, my learned friend will be able to say exactly what amount of money they got. There are 100 cooperative societies, 100 cooperative societies who are selected. This your lordship will be pleased to find from the very, your lordship will be pleased to come to page, there are, your lordship sees a 94 has been given there. So we will be able to calculate on the basis of this. Kindly come to page 28. Category-wise reservation of plots, page 28. Yeah. Your lordship sees this block of handwritten. The first one, categorized reservation, your lordship has got that, page 28. Kindly see this total of 52, 27, 15. This comes to 94. So I am proceeding on the basis of round figure 100. So 100 cooperative societies we have been allotted in terms of this Urboshi 52, CMRI 27 and KSTP 15. So, my lord, if we proceed on the basis of this, these 100 cooperative societies have come before the court and they are saying that this is the amount of money we have paid in the year 2010. Today we are in 2026. 16 years have gone by. The allotment of the plots have not been made, even though we have complied with the terms of the brochure, word for word. And this is, my lord, our grievance. My lord, we have come before the court for the purpose of getting justice. These are people who have put in their good money in the expectation of getting some blessing. What has happened is this. Soon after this, a sort of dispute has been sought to have been raised between Steel Authority of India on the one hand and this Development Authority on the other. Steel Authority is saying that this is my land. how could you have allotted this to these people? And Development Authority is saying, no, this has been allotted in our favor by the government of West Bengal. The land belongs to the government, land that does not belong to you. Now, this is the dispute which has arisen. A suit has been filed, my lord, in the lower court. Order of injunction has been obtained, restraining, my lord, Development Authority from allotting the land. And that interim order is continuing for all these years.
Suit is filed by whom?
My lord?
Suit is filed by which authority? SAIL.
Yes. And my lord, this dispute, when it came before the court, naturally, my lord, before the matter came before the lordship, it was before another learned judge. And my lord, naturally, the learned judge was moved by the fact, this kind of fact, this is a gross fact. You take money from me, the promise of allotment of land for the purpose of construction of building for residential purposes, and then you forget all about it, go into litigation, obtain an order of injunction, and allow the injunction order to continue for years together, for 16 years. My lord, I shall show your lordship, my lord, this order which was passed by your lordship's predecessor, my lord. আমাকে অর্ডারটা দাও। My lord, I will give your lordship a copy of the, show your lordship a copy of the order. My lord, this is an order which is এটা কোথায় পাবো? এটা কোথায় পাবো? কোথায় এটা? Lordship will please to, I shall take your lordship into that. Justice Vivek Chaudhary's order dated 25th August 2023. And that your lordship will please to find. I shall give your lordship a copy of the order, otherwise, my lord, এটা একটা কপি দাও না, বার করে দাও, আমার এই কপিটা দাও আর আমার কপিটা বার করে দাও। My lord, this order has been annexed at in one of the affidavits. It takes a stapler আছে, এটা স্টেপল করে দিয়ে দিই। I am sorry, my lord, it has been torn up. এটা কোত্থেকে তুমি পেলে? আমাদের আমি কোথায় মার্ক করেছি? Lordship will please to come to this order.
Yes.
It is dated in 2023. This order was passed in the presence of all parties. My lord, if I may place this order, affidavit in opposition file, etc. Then, my lord, your lordship will kindly come to the last page, last paragraph of the first page of the order. It is submitted by the learned advocate.
Yes.
It is submitted by the learned advocate for Durgapur steel plant that at present the dispute between the parties is attempted to be settled amicably. And for these reasons, series of meetings were held. As per the minutes of the last meeting, Durgapur Steel Plant Authority has prepared a draft compromise petition, which will finally be placed before the civil court, where the suit between Durgapur Steel Plant and Asansol Durgapur Development Authority is pending, after the compromise petition being vetted by the Asansol Durgapur Development Authority. It is also decided in the meeting between Durgapur Steel Plant and Asansol Durgapur Development Authority that the parties will file a joint petition for deletion of the names of the Union of India and the Government of West Bengal from the cause title of the said suit with the approval of the Asansol Durgapur Development Authority. Considering the submission made by the learned counsel on behalf of the Durgapur Steel Plant and Asansol Durgapur Development Authority, it seems to this court that a ray of hope is revealing in favor of the successful allottees whose phone numbers were published in Bengali Daily Anandabazar Putrika and the English daily, the Telegraph, on 16 September 2010. In view of such circumstances, both the Durgapur Steel Plant and Asansol Durgapur Development Authority are requested to settle the terms of compromise finally to be filed before the Civil Court in title suit number 38 of 2010, pending before the learned Additional District Judge Durgapur in appeal, as well as title appeal number 4 of 2013 within 6 weeks from the date of this order positively. The plaintiff in the said suit and the appellant in the appeal shall take steps for deletion of the names of the Union of India, State of West Bengal within the prescribed period. The instant writ petition is issued is for further order. My lord, this hope was, my lord, expressed by this honorable court as early as on 25th of August 2023. My lord, we are still waiting for this settlement to come through. This still, my lord, the suit is pending, kept pending. No settlement has yet been, we have not heard of any settlement having been arrived at, even though the learned counsel, responsible counsel, who had been appearing in this matter, had promised before the court that the matter will be settled. Why? For the purpose of bringing some ray of hope, my lord, in these these members of the cooperative society. My lord, kindly see, there are 49 cooperative societies who have been added in these proceedings. They are all, my lord, before your lordship. They are saying that time has come when we should be given this. But this entire amount of money has been held up for all these 16 years, 14 years. But I think the conscience of the court should, my lord, be shocked by the way, my lord, two my lord, mammoth government bodies fighting with each other. Whether it's a show-off fight or actual fight, we do not know. Promise has been made that the matter would be settled, so that, my lord, this particular the promises made in the brochure could be implemented. But there is no attempt. I don't know what kind of, my lord, the government, what kind of government is running, my lord, the business of its, and see, my lord, the promises, the rosy promises made for the purpose of development of a particular township, so that, my lord, it will improve the infrastructural facilities, industry, habitation, everything will be improved. That was the promise with which, my lord, this land was allotted by the government of West Bengal to, my lord, this development authority. My lord, I submit to your lordship, my lord, the time has come when, my lord, your lordship should pull them through, pull them up, my lord. The problem is this: what is being shown to us and shown to your lordship is an order of a district court. The interim order of injunction has been obtained by one party, one government body against the other government body. And this particular interim order had been obtained in 2010. It is continuing till 2026, to the utter detriment of these people. My lord, in this connection, I will show to your lordship one document which I thought perhaps should be placed before lordship. This is, my lord, an CAN application in which this document had been annexed. It is revealing document. So, and it is written by Asansol Durgapur Development Authority, addressed to the Principal Secretary, Urban Development and Municipal Affairs Department, Government of West Bengal. This, your lordship will please to find.
What is the CAN number?
This is, my lord, CAN number 47 of 2024.
CAN 47. CAN 47. Exception of fine resurrection.
তো উল্টো পাল্টা বুঝিও না, এটাকে আমরা সেটেল করবো বলে সেটেল করছো না কেন? আমরা কি রাজি হবো? তোমাদের মধ্যে জোগাড় হচ্ছে, আমি রাজি হব। Sorry, Malad, this is aside. I am being rather strict with my learned friends. I can, my lord, if I may say so, I can exercise my authority because of my long standing at the bar on these juniors before your lordship, including this junior also. So, my lord, I'm saying that this is what is happening. Do something about it. After all, we have got some duty to our own people. And I'm submitting to, I'm requesting my learned friends that do something about it so that, I mean, something can be got out of it, and these small people can get some benefit out of this. Lordship will kindly come to page 29 of this. This is a letter written on 9 July 2018.
Yes.
To the Principal Secretary, Urban Development and Municipal Affairs Department. Well, I will request your Lordship to come to page 30. B. In subparagraph B, mode of acquisition of land at Durgapur and Asansol. That is how, my lord, the paragraph starts. It is learned that in respect of Durgapur, the land which are involved in catering residential development at Durgapur were in possession of, it should be Hindu Steel Company for a long time. Later on, the said company has been substituted by Durgapur Steel Plant SAIL. And after having mutual discussion between SAIL and ADDA, the L and LR Department, Land and Land Revenue Department, Government of West Bengal, has finally published a notification on 5th September 1994. Thereby, the Development Authority has received possession of 399.468 acres of land for catering to development at so and so, and the Mosas have been mentioned. In respect of KSTP at Asansol, this Kollanpur Steel Authority at Asansol, the land was acquired in LA case number so and so, along with other plots by the collector Burdwan in favor of Housing Department, Government of West Bengal. Thereafter, said department, through recommendation of the high-powered committee, had handed over the advance possession of the said land in favor of Development Authority by way of map number so and so, and has made a payment of rupees 372 lakhs for receiving possession of the aforesaid land. So, my lord, the money is going from one pocket to another. Proposed allotment of land through lottery. It is necessary to convey that regarding allotment of lands at Urboshi at Durgapur, there are 3 phases, out of which allotment of residential lands at Urboshi phase 1 and phase 2, along with construction of housing thereon, has already been completed. However, disputes, including court cases, have been arising in respect of the allotment of land at Urvashi phase 3. The detailed reference in respect of allotment of land in Urvashi phase 3 would appear hereinafter. The Urvashi phase 1 was taken up in the year 2001 for catering residential accommodation at Durgapur by Development Authority for the people of the said areas. In the first phase, that Urvashi phase 1 of development, 131.45 acres of land was involved, and it was developed on public-private partnership model, in short PPP, with the aid of Bengal Ambuja Housing Development Limited, in short so and so. When such development by Bengal Ambuja was taken up, 75% of the aforesaid 131.45 acres of land were developed by them, and the rest of the portion was handed back to Development Authority for future development. Consequent to which, the scheme pertaining to Urboshi phase 2 was taken up by the Development Authority in the year 2002. My lord, the history is here, so my lord, I am placing it before your lordship for your lordship's kind consideration. The next page. It is also a fact that in dealing with allotment of land at Urboshi phase 1 and phase 2 was brought to the knowledge of Steel Authority of India DSP by the Development Authority. But since no response to the extent of 75% of the reservation of lots was received by the Development Authority from SAIL/DSP, hence the unutilized quota was allotted by Development Authority to the members of the public. The allotment of lands made by the Development Authority in respect of Urboshi Phase 1 and Phase 2 were successful and no litigation has cropped up in respect of the said allotment. So, my lord, your lordship sees that Steel Authority of India is clamoring and filed a suit for the purpose of allotment of a portion of the land in the court, district court, and obtained interim order. Whereas, my lord, when it was allotted to them, they had not shown interest in a large part of it. 75% of the reservation of the plots, my lord, just went abegging without there being any response from the Steel Authority of India. Then, my lord, while launching the scheme at Urboshi Phase 3 in April 2010, 100% of the fund lands were offered for allotment to the public by your lordship sees is an admission through open lottery in favor of group housing cooperative societies. And this is, my lord, what I am on. But dispute arose as to whether Steel Authority of India on the terms of allotment, which led to subsequent court case. In respect of KSTP in Asansol, lottery was conducted, but allotment of land has not been processed by the Development Authority till date in respect of KSTP Asansol. It is also necessary to mention that physical possession of the lands at Durgapur and Asansol are lying with Development Authority, and due to pendency of court cases, no allotment has been processed by the Development Authority at both Durgapur and Asansol. My lord, I am submitting to your lordship, my lord, looking at this, why is it that a suit which was filed in 2010 should be kept alive and, my lord, till 2026 for the purpose of preventing, my lord, proper allotment of the land for which, my lord, this brochure was issued? Then, my lord, kindly see the schedule of plots in respect of which lottery was conducted. These are all admission. Lottery was conducted on 14 September 2010 are mentioned below. And your lordship sees Urboshi Phase 3, exactly the same, which I have placed before lordship. That particular thing has been quoted at pages 31, 32. And then, my lord, litigation at page 33. What is this litigation, my lord, we are talking about, which cannot be settled, my lord, for in 16 years' time, from 2010 to 2026? And every time, my lord, they come to court and promise that it will be settled. Yes. Litigation. However, Steel Authority of India, DSP, felt aggrieved with the way of conducting lottery by the Development Authority in favor of group housing cooperative societies. Why this stepmotherly attitude of the Steel Authority of India against these small people? And filed court case against the Development Authority in May 2010, which was registered as title suit number so-and-so. And after hearing the parties, injunction was granted by the court on 20th September 2010. And after hearing the parties, injunction was granted so-and-so against such distribution of land by Development Authority. Meanwhile, Development Authority had held lottery on 14 September 2010 and published the result on 15 September 2010. But it was mentioned that the result of the lottery was subject to the result of the suit. However, on 20th September 2010, Learned Civil Court granted injunction against Urboshi 3, which is continuing to operate till date. And as such, the Development Authority could not issue allotment letter to the societies who were successful in lottery. My lord, the entire case, so I am arguing for lordship, my lord, is contained in this letter. The said stalemate is persistent in respect of the plots located in so-and-so colony, but by way of modified court's order issued on 4th October, so-and-so, it was declared the court that there was no restraining order in respect of the plots in KSTP. So far Kollanpur plots are concerned, my lord, it was made clear. Then term of compromise entered into by SAIL and Development Authority. Later on, in November 2010, both SAIL and Development Authority has decided to enter into compromise for allotment of lands as per MOU signed in the year 1994 and executed in the year 1998 in respect of Urboshi Phase 3 in favor of employees and ex-employees of SAIL DSP. And after having protracted discussion, it was agreed by the parties that SAIL DSP was entitled to 70% reservation in in 52 plots in Urboshi Phase 3, as also in another unpublished scheme of 45 plots adjoining Urboshi Phase 3, amounting to a total reservation of 68 plots, being 70% of 97 plots. Therefore, Development Authority would offer all the 45 plots adjoining Urboshi Phase 3 and additional 23 plots on separate Development Authority land in Fuljhor for Steel Authority of India employees, ex-employees in lieu of 58 plots in Urboshi. So, my lord, this was the sort of understanding between the parties that instead of going into Urboshi, which is, my lord, our clients are, my lord, clamoring for, so you will be shifted, and that was agreed to. That insofar as 52 plots are concerned, it would be released. But there will be some amount of relief on our part. Steel Authority employees, ex-employees in lieu of 52 plots are in Urboshi Phase 3. So they would move to Malad Mouza Faridpur, so and so plot land for unpublished scheme of 45 plots. Steel Authority of India, DSP, was provided 75% reservation over 7.921 acres comprising of so and so. Well, this is Kalnemi Lanka Bhag. I don't know what is happening. These two parties are, my lord, we wanted to join in that suit for the purpose of espousing our cause. That application was rejected by the district court. Why? Because it was found that we were not necessary or proper party in respect of the dispute between the two parties. Very well. If that is so, then when you are considering this, then should you not take in note of our concern about it? And that is not one. 100 cooperative societies are waiting in the wings. They are all, my lord, the additional parties, they have come up before your lordship. Now, my lord, I submit to your lordship that this is what is happening, that some amount of compromise, some amount of settlement had been gone through. They themselves are recording that this is what is going to happen. Why is it that they are not implementing this? I don't find any explanation. Kindly see, my lord, again, if I may read it again, my lord. Your lordship will kindly take last paragraph at page 33 about the middle of it. It was agreed by the parties that Steel Authority DSP was entitled to 70% reservation in 52 plots of Urboshi Phase 3, as also in another unpublished scheme of 45 plots adjoining Urboshi Phase 3, amounting to a total reservation 68 plots, being 70% of the total so and so plots. Therefore, Development Authority would offer all 45 plots adjoining Urboshi Phase 3 and additional 23 plots on separate, kindly see, in Fuljhora for Steel Authority of India's employees in lieu of 52 plots in Urboshi Phase 3. For Urboshi Phase 3, 52 so and so acres for unpublished scheme of plots so and so. Then, my lord, and kindly see the 23 plots at Fuljhari, that has also been mentioned. Approvals were granted by competent authority of Steel DSP as well as Adda Board for such settlement, following which a joint compromise petition was signed by Development Authority and Steel Authority before the court of Durgapur on 19th April 2017. So after 7 years, this is what has been arrived at. The said compromise petition was rejected by the court by way of an order dated 9th April 2030. We are not being able to even, well, what should I say, put my voice into this because I am not a party to it. So what is happening, my lord, we do not know. And this suit is still pending. After, my lord, they have agreed into this. This is alleged to have been dismissed, and we don't know anything about it. Thereafter, still DSP filed a civil revision petition, which is sub judice before the court of learned additional district judge Durgapur. Well, I would request my learned friend to inform your lordship that after 2018, this is a 2018 letter, thereafter 6 years have passed. What has happened to this, my lord, this application for revision? The revision hearing was pending in sub judice, my lord. I would request my learned friend, my lord, to inform your lordship of what is happening to this. তুমি বলো, উত্তর দাও। Then, my lord, introduction of land
allotments have not been made due to the pendency of the civil suit. This is the only crux of the matter. Time and again, the coordinate bench as well as this court has also gone into saying that you take steps for compromise or whatever by an application. What is the stage now? You resolve that, and this is going on for long until and unless you come up with a definite.
And my stand is absolutely clear that I am not interested at all in the pricing of the land. I will not get a single penny. Agda will get it. So that is the pricing aspect is exclusively to be answered by Agda. But there, I want to make one submission. The price, regarding the price, the problem is created by the clients of my learners and themselves. Because the price they say that will be escalated as per the present market value, that is based on the basis of their own stand, which according to me is wrong. Why I say this, not trying to take the position.
But then what is the option way out to resolve the issue?
In my I'll clarify one thing and then I'll answer your query. Regarding the price aspect, I just clarify that and then answer your question. My lord, your lordship has come to page 26 of the disposition. It was shown to your lordship a schedule showing the price of the land depending on the category of the plots, 12 kata, each kata, like that. Your lordship has seen that. What was the price? Price is 2,50,000 per kata. 12 kata means 12 kata will make it 30 lakhs. 10% of it you deposited, which is 3 lakhs. In case of lesser quantum of land, the deposit is less, like 2,50,000, 1,50,000, like that. This is to be deposited not by the individual members. Who is the applicant? The applicant is a cooperative society itself, which may have many members, 15, 16, or 20 members. But the deposit is to be made by the applicant, which is a society that is one deposit only. 10% for 12 kata land, only 3 lakhs. That's all. Now, what is the nature of that deposit? Kindly see that. In my humble submission, this deposit is an application money which is refundable in respect of unsuccessful applicant. This is, according to me, in the nature of an earnest money. It is not a part consideration, payment of part consideration at all. If this position was not raised by my learned friends that we have paid part consideration, no problem would have arisen at all till today. If they accept that these are paid by way of earnest money, the government stand, which says now that that you have to pay the balance of the amount at the present market rate, where you have made a part payment. If they say that it is not a part payment, it really was not. When application money, honest money, refundable for unsuccessful bidder.
But then there is a clause that 10% will be adjusted against the rest amount.
Of course, we are in every.
So how do you say that?
In respect of honest money, also the same thing is done in respect of all tenders. Honest money is not taken separately. Honest money is to show your honestness to go into the aspect, into the deal. Now, once your deal is accepted, that money is to be adjusted from whatever balance is payable by you. It is to be adjusted. But this is not past payment of the consideration. I cannot take consideration money from an applicant who has not been chosen, not selected. Therefore, why do they say that they have made past payment of the consideration? That is where the government has laid the trap. They are following in that step. They are kindly take one thing, the report filed by the state. The report filed by the state, kindly take that.
Lottery has been held.
Lottery was held.
Allotments given.
Lottery was held. Election was made. No allotment. No plots were allotted. What is my stand? I am civil authority. Entire land belongs to me. I surrendered it to the state. But then, my lord, Adda, while Adda was creating this housing project, etc., now we said that since the state government is giving to you for the purpose of housing project, why should my employees be deprived also? The housing project, everybody should be allowed. Now there, we claim that 70% be reserved for us, our employees. Adda accepted that. I don't know whether they accepted it or not, but the proposal was prepared between Adda and Cell that 70% will be allotted in favor of the employees of civil authority. That proposal was made, a draft agreement was already prepared. It was sent to the government for approval. Then the government submitted a report as per the direction of the court. So what is your stand on this? The government said, one part of the report says, that if you had paid, if the party has paid part consideration, then the balance has to be paid out of as per the present market rate. But if it is, if what I say that it is not part consideration, the application money is honest money. It is not part consideration. Therefore, that clause will not apply. They will not have to pay as per market rate. Plain and simple thing. You know, kindly see the government report. Kindly see the government. The last page of the government was a 3-page report. The report is dated by 22nd April 2024.
A report filed by the state.
Yes, state. But the special secretary to the government of West Bengal. Urban development. Report extra copy আছে report extra copy দিন না গভর্নমেন্টের রিপোর্ট গভর্নমেন্টে কি আসছে আপনি আমি জানি রিপোর্ট দিতে পারবো আজকে রাতে 22nd April 2024
এটা কোথায় আছে ভাই?
Kindly come to page 3 of this report.
Can I have a copy of the report?
At the top.
Government a copy of the
At the top.
report.
Where as per at the top of this. At the top of page 3.
Well, this report is being placed before Lordship. A copy should be given to us.
আপনি কি বলছেন এটা?
না আমি জানি না।
এই রিপোর্টটা আমি প্লেস করি।
আমি কোন রিপোর্ট আপনি দেখাচ্ছেন? I am not placing that report. I am placing the report of Adda. And that report contains everything. This report, I don't know where this report is.
What he has referred to, that is a part of CAN 47. It's a letter of communication to the principal secretary.
This report was submitted to the court as per court's direction and handed over to all the parties, including me. In fact, we report by
একটু দেখো এই কপি কিনা
it was separately submitted, not by way of
রিপোর্টটা
affidavit.
কিনা দেখো
22nd April. Yes, this one. এই রিপোর্ট সবাইকে দিয়ে এই তো আমার কাছে
ক্যালকাটা হাইকোর্ট অর্ডার দিয়ে দিয়েছে এই রিপোর্ট ইজ নট অ্যাপ্লিকেবল
আমি সেটাই তো
অলরেডি ক্যালকাটা হাইকোর্ট অর্ডার দিয়ে দিয়েছে
তাই বলছি
না না আপনি তো স্যার
আমি তো
on this issue already adjudication has been held in some other on this same area same issue
suppose if you are to kindly text page first page of this report. This is submitted as per
decided হচ্ছে ওই কেস
order of this honorable court.
এটা কি
which part
At the top, where
No.
as per the offer of allotment, where has the lawsuit got it?
no no no
At the top of page 3. At the top of page 3.
yes
Where as per the offer of allotment, here there is no offer allotment yet. Past payments has been made. Past payments has not been made according to me. This is an earnest money taken by Adda, which is refundable
balance amount
for unsuccessful bidders. The
Yes.
allotee may be given opportunity to pay the balance amount as per current market value. My land friend is objecting to current market value being paid.
this is wrong
His argument I fully accept. Why should they pay at current rate? Because this clause does not apply to them. No allotment has been made. If where as per offer, where is the offer allotment here? Then past payment has been made. Where is past payment made? So why this current market value concept to be realized at all? This is not to be paid. Current market value.
but then a notification coming on 2024 when the offer was made in the year 2010
2010
how it will have a
This comes
retrospective
from the government. I have nothing to do.
গভর্নমেন্ট
I am civil authority.
সবসময় ভুল বলে এখনো
The civil authority along with Adda has submitted a proposal for under order 23 rule 3 for compromise. That was submitted. I mean that was prepared and sent to the government for approval. The government did not approve because they say that we have made past payments. Then government said we pay at per current market rate the balance amount. Now that stand itself is wrong. This clause does not create
is for the state now you
What has state got to do with it?
because they are referring
But,
to a
But I shall,
notification
my submission is very simple. The state has allotted this land to the development authority. Development authority has issued this brochure. Land premium has been mentioned. Well, I am just giving an example to your lordship. If I file a suit for specific performance of an agreement for sale of a plot of land in say 2026, and if the suit comes of a hearing in 2046, then my lord, when a decree is passed, does the court say that you pay the price at the market value in 2046? Specific performance is granted on the basis of 2026 price on the date on which the agreement was entered into. How can the government say that you pay the market value? It's a dispute between my learned friend is appearing for Steel Authority of India. State of West Bengal is not a party to it. Argument is made by the Steel Authority of India in respect of the price which I am to pay to the Development Authority. Development Authority is not saying so. Who is Steel Authority of India to say dictate this thing? But these absolutely absurd things are coming up. This only goes to show, my lord, that who is putting a spanner in the works. This is a clear example of collusion between two government bodies for the purpose of depriving these small people.
No, I think I have been misunderstood by my land. I say that his clients are not required to pay as per the current market. That's my specific stand. I am being misunderstood. I'm sorry to say this. I say no offer of arrangement has been made, no past consideration has been paid. Therefore, why should this clause apply at all here? Current market price is not to be paid, it has to be paid at the old date. That's my stand. How can my learned friend say that I am siding with somebody to deprive them? I'm supporting their stand that only the price as was determined earlier, that is to be paid, nothing else.
Okay.
Now, so far as the registration charge is concerned, the land has to be registered after allotment. Land has to be the document, the executed document has to be registered. What should be the registration fee? Would it be at the rate of 2010 or at the current market? That's a different aspect. Because registration rule under the Stamp Act regarding registration of documents says that the registration charge has to be as per the current market. The document has not been executed. It will be executed now. If the case is over, it will be executed now, and within 4 months it has to be registered. Now, registration charge will have to be paid at what rate?
Well, the Authority of India is espousing the cause of both the state of West Bengal. I'm very glad, my lord, that the government of India, my lord, body is taking up the cudgels on behalf of the state of West Bengal in respect of stamp duty, registration charges, and on behalf of the development authority with regard to the price.
Because my learned
So, my lord, I'm very glad about
my
it.
learned friend
That
is
this only
missing out.
goes to show, my lord, how the
My
conditions.
learned friend is missing out on one point. I am interested in my employees also who have 70% stake in the land and making a payment.
We do not accept that. This is what you are saying in a suit. We do not accept it.
This is a suit for. And the compromise petition is it will filed in that suit. His clients are not parties there.
But their rights are affected by the suit.
Their rights are affected. Rights are not affected by the court. The court says file a compromise petition between you two, and there before filing it, I seek approval of the state government because the state government had in the meantime 2012 had issued circulars regarding how the price is to be fixed and all that, and said that before doing before finalizing anything, take our approval, urban development department. We sought approval, government sends this report as per procedure. And this report was yes to contradiction.
My lord, may I, apropos this submission of my learned friend, draw your lordship's attention to again page 31 of this the report of my lord, the development authority. Just now I am showing to your lordship, my lord. Kindly come back to page 31 once more. After this, my lord, how can they, my lord, make this submission? Kindly, my lord, come to the page 31 top. This is, my lord, the development authority is writing. It is not my letter. Kindly see, my lord, the first paragraph. It is also, your lordship has got that, page 31, first paragraph. It is also a fact that in dealing with the allotment of lands at Urvashi Phase 1 and Urvashi Phase 2 was brought to the knowledge of Steel Authority of India, DSP by Adda. But since no response to the extent of 70% reservation of plots was received by Adda from Steel Authority of India, hence the unutilized quota was allotted by Adda to the members of the public. This is what has been said. How my learned friend can contradict this? This is the first paragraph at page 31. Because they did not respond to 70%. Then it was allotted in our favor. Then the brochure was issued. Then we made our offer, deposited the money. The money has been pocketed by the development authority, and for 16 years no land is being allotted to us. What is happening, my lord? This is a collusion between the two government authorities.
We'll hear you on the next date. You make your submissions. Thereafter, Mr. Mitru will make a request. Next week again.
Well, I shall take 10-15 minutes more, my lord.
After he makes his submissions on behalf of the development authority, thereafter you conclude your reply.
Very
initiative. You have the copies? kindly serve. Mr. Mitro, kindly give copies of the report and the pleadings to learned
Yes, but
advocate
then
because
I shall have a look
he
into
is
it.
appearing for the first time, I suppose. So you get instruction regarding the report that has been submitted.
I'm gonna get a copy of the report.
Or Mr. Mitro, learned senior advocate. Joyanta Kumar Mitro, learned senior advocate for the petitioner.
এসব করেছেন এখন বলছেন wait করছি।
Mr. Lukki Gupta, no? Lukkikanta Gupta, learned senior advocate for sale. Also places his argument. Due to paucity of time, hearing could not be concluded. Leaves this matter next week, follow.
And it
12. 2 p.m. Okay, assignment job.
on account of
On 12th, 2 p.m.
on 12th.
12th.
12th, Lordship.
That is what I have recorded.
And in the meantime, my lord, I shall request my learned friend, both my learned friends, I've got highest of respect for them. I'm sure they will be, if they put in a word with my lord, their respective clients, I'm sure the matter can be said. For 16 years, the matter, my lord, they're hanging fire.
No, I have no question about the price. I do not dispute.
You settle your no, I am not on that. I say that you settle your disputes among you. Forget about me for the time being. Settle your disputes so that I can have the matter heard by your lordship. No, my lord, the stumbling block which is being put in front of me is, my lord, the interim order which has been passed, which is pending for 16 years.
So
It's scandalous, absolutely.
The aspect of pricing is not to be decided by the civil court.
No.
Then what is the obstruction in compromising the suit and coming back to the read court regarding the pricing?
We
Decide on this aspect. What is the notification of the government and what's the price?
Between sale and Adda, a compromise was like that. It was sent to the government for approval as per the policy of 2012, because the Urban Development Department said that whenever you settle anything in respect of land, have it approved by us. It was sent to the government sent this report.
So, madam, you take instruction regarding what has been discussed right now, and come back with the necessary instruction. What will be the pricing and all? Then they will go for this resolution before the civil court and will dispose of
Lordship,
that.
can give you 1 minute because I have got my own apprehension. আপনারা 12 তারিখের মধ্যে ইনস্ট্রাকশন নিয়ে আসতে পারবেন? শিওর তো? Lordship.
State is directed to seek instruction and inform this court on the returnable date. আরেকটা ম্যাটার আছে 141 টা আছে Mr. Mitra,
that matter probably
next week.
I'll
Who
come
is-
back next Wednesday.
Who is for the petitioner?
Hello, my learned friend. Next Wednesday.
Next Wednesday.
Not this Wednesday.
Then not
The same.
not today.
Sir,
Yes, yes.
only let it retain its position. Yes.
Okay, thank you. Yes, next week. Yes.
Lordship, in the 3 p.m. fixed matter, Lordship, I am there for the petitioner, Lordship. Mr. Ghosh is on legs before courtroom number, Lordship, 18.
No, he was arguing little. This one. এটাও আছে পেপার ওদেরকে মেটেড আসছে না
আমি আমার কাছে শুধু
ফিক্স যেটা আজকে হলো
রিড পিটিশন
না রিপ্লাই দিনে হিয়ারিং করবো হিয়ারিং তো হয়ে গেছে রিপ্লাই যা দেবে না তাড়াতাড়ি করে দেওয়া যায়, যাতে আমি করে যদি না অর্ডার দিতে পারি তাহলে আরেকটা দিন পেয়ে যাবো। 13 তারিখ অর্ডার দিয়ে বলে তার আগের থেকে একটু এগুলো না। ঠিক আছে।
My lord, let me allow to mention that is 98 for assigned matter, my long proceedings, my lord. Today's listed.
Next week we'll see. Why you are not appearing?
Yes, I am appearing, my lord.
Matter was called on, none was there for the petition. Who appeared for the state? How, Mr. They will not be there for the state.
Yes.
So find out who is for the state, who has been assigned, give a copy to him or her. The next week we'll see. Next week, the matter will be in the list. Next week we'll check it.
Much obliged.
কাগজ
There is a paper book, my lord.
আগে নোট নিচ্ছিলাম যে একটা এই তো কাগজটা শেষ হয়ে গেছে বোর্ড Yes, Mr. Daswood.
Kindly come to page 545. I was dealing with
you are referring from which writ petition?
From my writ petition, my lord, it will be there in the paper book, my lord, possibly.
ওইটা দিন না দেবনাথ বাবু
Your lordship can take my writ petition also, huh?
এইটা দিন এটা পেপার বুক আছে
এগুলোতে সব আছে। Book of what? Oh, it is writ petition. Oh, well, this is possibly the writ petition itself. One writ petition. What's writ petition? Our writ petition. I thought it was a paper book. Page 545. This is the order of the appeal committee.
Yes.
My lord, absolutely at the top, my lord, there is a line, in absence of any rules, it is not open to the disciplinary authorities. Similarly, my lord, this ground is very central, my lord. I will deal with this, all this separately, my lord. Whether if it is whether it is open to designate any act or omission as misconduct, or whether it has to be defined in the rules. Every misconduct as per the
this you have referred to rule 8.
Rule 8. Yes, ma'am. I will deal it in because I will be showing judgments also on that issue. So I was mainly dealing with the clause 5, my lord, the bottom. I was arguing on this, my lord.
Yes. Clause 5.
Clause 5, my lord. It says that with reference to charge, it appears from report inquiring authority held that charges are proved relying upon oral evidence given by some teacher. If your lordship remembers, my lord, the charges that in various resolutions, signatures of teachers were not available. So it was their contention that instead of in fact, the inquiry officer has also told that instead of raising an allegation by writing it, you should have put a dissent note in the resolution itself. That was their, the appellate authority is also held that. Well, kindly see. Now, I had argued on the last date. It is the discretion, my lord. When both things, if I could have, I have not. Even if I raise the allegation, it does not take away the allegation. It does not take away the allegation only because I have not signed a dissenting note. Rules, in fact, he is a very strict follower of rules, the appellate committee.
then there should be a rule. Your logic should have a single thread. It cannot be different for different issues. If you say in one case the misconduct has to be defined in rules, otherwise it is not a misconduct. On the same ground, if you say that a dissenting note has to be put in a resolution, the teacher just cannot refuse to sign. There has to be a rule which clarifies it. So whether the teacher has signed, put a dissenting note or has subsequently filed a complaint does not make any difference. The fact remains that the resolution did not have signatures and decisions were taken without signature. You will kindly come to page 53. You will come to page 45. This is the hearing sheet. And question starts from here. Then your lordship will come to, this is the page 45, my lord. Hearing sheet.
Page 45
of the writ petition. Same. This is annex. এটা কি? না না এটা writ petition না আমাদের।
যে আপনাদের যে রিট পিটিশনটা এটা হচ্ছে এই বড় পেপার বুকটা এটা 45 পেজ
ঠিক আর কি লেখা আছে
that is not there. Page 45 is not the question answer. Charge start with page 59.
Maybe, maybe.
Can you indicate the page number?
But the relevant point, the point I was, the question I was is page as page 53. Question I was referring to is at page 53, man. I thought this.
No. This is not matching.
Start কোথায় হচ্ছে? Start কোথা থেকে হচ্ছে? 1, question number 1. 46. Page number. This one. 18.8. The same village. Question answer. After the typed complaint হবে teachers a complaint এর পরে R1 এটা কি করছে এটা তো ওটাতে সব আছে এটা
It's a handwritten question answer form.
Yes, question answer.
What is the date of that?
The question answers date is 18/8/2024.
18/8.
Question number 29.
Lordship, from our writ petition, I can produce lordship. Nah.
Can you tell me the date?
Lordship, in our writ petition, it is page number 55.
35.
It is
55.
in our affidavit in opposition possibly. So সেই জন্যই তো আমি বলছি।
Also, I'm trying to figure out the page number from the big one, but for
what is the page number? Tell me.
In our writ petition, it is page number 55. He is indicating to question number 29. Yes.
55. Correct.
Lordship has found lordship at the very top.
This question 29, your lordship has not.
Yes.
আপনার রেজলিউশন খাতা থেকে দেখা যাচ্ছে যে প্রতি পাতা শিক্ষক সমিতির সভা সকল শিক্ষক শিক্ষিকাগণের কোন টিচার্স এর সই নেই কেন? So very specific question that there are signature, none of the teachers have put their signature. Answer is এটা মানতে পারলাম না, কোন টিচার্স সই করেনি এরকম হয়নি, যারা অনুপস্থিত থাকে তাদের সই হয়তো নেই।
Where is the copy of the resolution?
My lord, resolution of copy ta ache? Well, I'll try to, because possibly I will not be able to finish today. Next date I will find it, my lord. अरे क्या evidence नहीं बना? একটু পড়ো তো ঠিক আছে 28/7/11 সভায় আপনার লিখিত অনুযায়ী আলোচনা হয়নি কেন? মানে the main issue was this issue of collection of money. It was no resolution was being taken. No decision was somebody one was possibly was these issues were not discussed with all the teachers. Well, main that is also separate charge.
Collection of money through forms.
Through on several issues. That is in itself a charge. That they were not supposed to collect money, but they have collected money. The teacher in charge has collected money. Under the rules, they are not allowed. The appeal committee has that as per memo, which says that 240 rupees can be collected and anything can be done as long as it's 240. So, whether the issue was when you are taking these decisions, you should include everybody. Defense is that somebody was not present. Possibly that is why it is not being signed. There is no proper defense, my lord. Defense has been set up. Well, reply to this is এই মুহূর্তে মনে পড়ছে next question 30 minutes এই মুহূর্তে মনে পড়ছে না আমি শিক্ষক শিক্ষিকা স্বাক্ষর করিতে অস্বীকার করান এমন কোন লিখিত বয়ান রেজলিউশন এটা কি থাকা না এটা নোট দেননি সেম রেজলিউশন খাতায় নোট দেন
Lordship, in the writ petition, it is going at the page 345.
Here.
The big one. Their writ petition.
আমাদের এ হতে আছে
Is reading from page 345.
এই পার্টিকুলার কোয়েশ্চেনসটা তো
Questions and answers.
Yes. Thank you.
Now, my lord, we'll come back to page 545, my lord. I am reading the appeal committee's opinion on this.
Yes.
With reference to charge number 5, it appears from the report that inquiry authorities held the said charges as proved relying upon oral evidence given by some teachers before him. It appears from the charge sheet that the said imputation are based on question number 29 and 30 of Exhibit 1 on perusal of evidence adduced by some teachers being PW3, PW4, PW5, 6, 7, PW8. Appears that they did not put their signature on the resolution since those were not properly adopted. On perusal of the copy of the resolution placed before us from both sides, it appears that none of them made any adverse comment on the resolution book itself, while it was admitted that those were adopted in their presence. It was open to them to bring the reasons of their dissent on record. But none of them did the same, and they made a complaint, Exhibit 2, against the delinquent after the preliminary inquiry dated 5/8/2013. And it was nothing but an afterthought measure adopted by those teachers. This is important. Adopted by those teachers to shift the responsibilities on the delinquent. And this aspect of the mechanism was overlooked by the inquiry authority for the reason best known to him, though those were very apparent on the record itself. Therefore, in our opinion, the conclusion arrived by the inquiry authority is premeditated and bad in law. So now the allegation has been shifted. They say that this whole thing is premeditated. The teachers, because they have not and have because they have not signed the resolution and subsequently given a complaint, this is a ploy to shift responsibility. Absolutely after thin air, my lord. This is just presumption. Appellate authority will decide on the fact basis of evidence and merit. He is the president appellate committee. Appellate committee is proceeding on random conclusions without any basis. If it was there, now they are making allegations against the disciplinary authority himself. The inquiry against the inquiry authority. In fact, my lord, most of it is against the inquiry authority. Final order has been summarily dealt with. Is premeditated and bad in law. So, Mala, the assumption is that the inquiry authority was proceeding with a prejudiced manner. That is what one can draw conclusion from the choice of words, premeditated and bad in law.
Yes.
Well, the next charge, my lord, this is your lords will kindly come to page 539. This is I'm for just showing the charge. What is the charge, my lord? Charge 6, my lord, at page 539. The delinquent had collected admission fees on different heads from 2011 to 2013 at the rate of rupees 170, rupees 190, 200, 220 from several classes, namely from class 1 to class 4, by violating the norms without taking any I repeat, without taking any prior permission from the competent authority, and no register was maintained for that purpose, and thereby the delinquent had committed serious misconduct by violating the rules of primary education, being a head teacher. My level, kindly remember this, because our charge is that you have taken some money time to time. Different head, under different head, not under one particular head. And subsequently, you have, without any permission, you have done it without any permission. And my lord, you have not even maintained any register for that. Threefold, my lord. Our charge is that you cannot take. This is the first charge, you cannot take any money. Primary school education is supposed to be free, completely free. So you cannot take. Second is you have done it without permission. Third is you have not maintained register. And now I will kindly see how it has been dealt with. I come back to page 546. That's 6. With reference to charge number 6, it appears from the report of inquiry officer that he held the charge as proved, relying upon hearing sheet dated 18/8/2014 and hearing held by him. It appears from the charge sheet that the imputation was made on the basis of question 20 of Exhibit 1 on perusal of the material placed before it. It appears that the delinquently admittedly collected fees on different head from school. Now it is to be ascertained whether she acted beyond authority or beyond rules by collecting those fees, and whether those fees come within the purview of admission of the expression admission fee as alleged in the charge sheet. It appears from the material placed before us that fees were taken on different head, like school maintenance, examination fees, annual sports, Saraswati Puja, diary, identity card, batch, and miscellaneous head, and amount varies from 170 to 220.
Yes.
The school in question is a recognized and aided school, and it comes within the purview of subclause 2 of clause N of section 2 of Right of Children to Free and Compulsory Education Act, and not a school established, owned, or controlled by the appropriate government or local authority. Print notification or the local authority. In terms of Geo number 187 SE law dated 14/2/2011, it was made forbidden from collecting any fees from the charge for the schools established, owned, or controlled by the state government or any local authority. And it is further stipulated that no recognized aided school or any school receiving aid or grant to meet whole or part of its expenses from state government or any local authority shall collect any fees or charges or expenses from a child till completion of elementary education other than a development charge up to maximum of rupees 240 only per year. So, my lord, there are two parts. Notification. এটা লাগবে এটাতে কটা Well, this is the notification. Notification copy আছে তোমার কাছে
হার্ড কপি থাকতে দাও
আমার কাছে
সফট কপিটা পাঠাও
So, my lord, there are two parts. First is a blanket ban. That from the word used is elementary education program.
Yes.
No money can be taken. Then a clause says that 240 rupees can be taken as development fees. Now, if your lordship comes back, the appellate authority, appeal committee is itself agreeing that money has been taken. How does it provide cover fire? It says subsequently, since the school in question is recognized, it may collect development fees not exceeded. Admittedly, the delinquent being head teacher collected fees ranging from 170 to 220. Therefore, the amount was within the restricted range as stipulated in the GO. It is also admitted that the said fees were collected on the basis of resolution adopted in the meeting of Mothers Teacher Association, and the delinquent only implemented the decision collectively taken by the said association, and these resolutions were not disowned by the Mothers Teacher Association at any time before or after the preliminary inquiry. No responsibility can be fixed unilaterally on the delinquent on the plea that she was the head teacher of the school. It was also admitted position that the admission of any child was not refused in academic year on grounds of payment of development fees. Moreover, the term development fees was not defined in the aforesaid GO, and the disciplinary authority has no right to interpret the same on his own wish and whims without referring the question to the government. Inquiry authority, while making the inquiry, did not inquire whether the delinquent acted beyond her authority and came to a conclusion on the basis of some surmise expressed on the part of disciplinary authority. Therefore, in our view, in absence of any clarification from the government, appropriate government, the aforesaid fees shall be treated as development fees.
But what was the amount collected? That is less than 240.
Well, this is the nuance here, my lord.
Because
This
the
fact is not
GO says 240 per year.
Development fees. Now, what does the record show? Admittedly, record show from time to time money has been taken. And all under different head, not under different. The appellate committee says, kindly see this line, in absence of any clarification from the appropriate government, the aforesaid fee shall be treated as development fee. He decides. And my lord, if your lordship come back to the charge. No, we head গুলো কোথায় আছে?
535.
Different heads.
539 is the charge. No?
Yes, my lord. So, my lord, no, different heads. My lord, it said different heads. With the heads.
Examination fee, annual sports fee, something like that.
Yes, my lord. From here, it's also it appears from material. He is himself recording it. It appears from this is at page 546. It appears from material page because the fees were taken on different heads like school maintenance, examination fees, annual sports, Saraswati Puja, diary, identity card, batch, and miscellaneous heads, and amount varies from 170 to 220. And now he interprets that even Saraswati Puja is development fees. His logic is that since this amount is under 240, development with any fees collected, any fees collected with, if it is within the, it falls under development fees, and the teacher in charge can do that. Our allegation is very specific. You cannot, in a primary school, you cannot take any money. You have taken money on different heads, thereafter without any resolution, and who has taken the resolution? A committee called parents committee, parent teachers committee. Parent teachers committee is not the school authority should decide it, or the government should decide it.
We stop here as of today. Date what? Charge 6 you have covered.
But this is a very long, but basically the is same. Charge 6 I will cover. Next day I will start from charge
17 days mudra. শুরু করা গেলে ভালো হয়, ফাঁকা রাখো দিনে তোমরা রাখবে না লাভ। You will take now.
I'll take some time.
19th.
I'll try to summarize as I'll try to.
Mr. Ghosh, in 19th August, 2:30.
19th August.
Yes, man.
2:30, I think.
Yes, yes.
Even if we can start at 3, we can complete.
So that it is finished.
By August, let's see.
Yes, I'm grateful.
Before your lordship rises, may my lord indicate one matter, my lord. This is appearing as item number 115. The only reason I'm traveling your lordship is this, my lord. The matter has been settled.
Sachin says, learned advocate for DPSC, yes. DPSC Howrah, who places his points of argument due to paucity of time. Hearing could not be concluded. This is matter 19th August at 2:30 p.m. 2:30 p.m.
May I just seek the liberty?
What happened?
May I seek the liberty, my lord, to indicate 115? The matter, the only reason I'm constrained to travel your lordship at this moment is, my lord, because, my lord, the matter has been settled out of court. Despite that, my lord, the compromise petition is only about to be placed before your lordships for passing the final order. Now, my lord, a warrant is pending on me. If your lordship is kindly please, this was also appearing as to be mentioned before the.
What is the section?
My lord, 138. It is arising out of a 138 proceeding, has now been settled out of court upon full payment. Compromise petition has been signed by both parties. It is only about to be filed. Now, my lord, this was appearing as.
Has been passed by the trial court.
Yes, judgment was passed by the trial court. Therefrom, appeal was preferred. During the pendency of the appeal, my lord, I shall place them. And my lord, the matter was appearing as to be mentioned before Justice Sengupta. If your lordship is kindly pleased to, my lord, keep it as to be mentioned, my lord, tomorrow or the day after, my lord. The only reason I am constrained to travel is, my lord, warrant is hanging on me and there was an order of stay. My lord, may I just indicate one difficulty here? My lord, there was an order of.
Was the warrant issued?
Warrant was issued, not warrant was under stay. The stay 28th January, it was a lordship.
Which year?
This year. Thereafter, there was an order of stay. There was an order of stay. The stay has now got vacated by, my lord, efflux of time. And, my lord, we could not get the opportunity to come before your lordships.
Next week.
If your lordship kindly pleases to, my lord, keep it as to be mentioned. It's just, it will take 2 minutes only, my lord, on any day, if your lordship pleases. It was appearing as to be mentioned. I have also brought, my lord, the last order that was passed.
Who is for the state?
My lord, state was appearing, I shall intimate. And, my lord, the private party was the one who was regularly appearing, and the person who is, my lord, supposed to, my lord, respond to the application. The private respondent, they have also signed on the agreement. She was here. The learned advocate representing the private party was here.
No, only her presence will be required. The person.
Yes,
they
yes.
have filed their affidavit.
Yes. No, the compromise petition has been signed by all parties. It has also been filed. Oh, it has also been filed. It has been filed as CRAN 4.
CRAN 4.
Yes.
all the parties are to remain present on the date it will come up.
But I shall intimate by notice to come on the next date of hearing. And if your lordship kindly pleases to
You know,
fix.
next Wednesday. Payment receipts.
Payment receipts all are there in the petitions. And next in the petitions, 115.
Parties have signed the CRAN.
My lord.
CRAN has been signed by both the parties.
Both the parties, yes. Compromise petition signed by both the parties, filed as CRAN 4. Your lordship kindly
Please
pleases
the
to.
percentage. Amount of compromise that is to be given.
The amount of compromise was not the original amount which was alleged to be taken by me, accepted by me from the opposite party number 2.
There is other percentage of amount has to be deposited before the legal services authority.
Lord,
After the order of the Honorable Supreme Court, certain percentage amount has to be deposited before the legal services authority.
that is not for acceptance of the appeal, for admission of the appeal.
No. When you compromise
138
under 138, if it is compromised before the trial court, the amount is separate. When it is compromised before the Honorable High Court, it is separate, and it goes to the Honorable Supreme Court, then it's separate.
But be kindly pleased to fix it. We shall come prepared on that. Lord, I can submit on that as well then. Lord, you kindly please to fix it on.
Mr. Agarwal একটা appeal করলো না? You will have to pay that.
I understand.
And also give a notice for appearance to be mentioned at a record.
Deeply obliged.
First next Wednesday, second half to be mentioned again. It will come in the second half. I will take it out under the heading to be mentioned to the list.
So deeply obliged, so deeply.
Huh?